All right. The 14th District Court for County of Washington, State of Michigan is now in session. All those having business for the court are near. The Honorable Judge Cedric Simpson.
You may be seated. Oh, Miss Linda or Miss Light, who's? Okay.
Ellie says on behalf of the people, the people with any kind of conflict between this honorable court and the public defender's office, but the people do not believe that there is such a conflict. Make this waiver and avoidance.
Thank you. Okay, Mr. Brown, your hand is up. Good morning. Lauren Brown, Deputy Chief Public Defender. Your Honor, likewise, we do not believe that a conflict exists. Honorable court hearing these matters. If conflict were to arise, our office would waive such conflict so that this honorable court could hear these matters.
Thank you. And the court, for its part, also does not believe there's conflict either in the court rules or the cases decided thereunder. To the extent a conflict does exist, the waivers, court will consent to hear the matters. Court does call the case of the people state of Michigan versus Willie Eugene Collins.
We're ready in that matter.
Good morning, Your Honor, to the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Willie Collins. Mr. Collins, please state your name for the record.
Willie Eugene Collins.
All right. Your Honor, today is the date and time set for the probable cause conference. I've discussed with my client a misdemeanor offer which has been offered in this case. I have, with his consent, assigned a device of rights plea form, and we also have the plea form here.
Okay. Plea form indicates that the defendant would be pleading guilty to the charge of use of methamphetamine, the 1-year offense. Upon his successful plea, the felony charge count 1 would be dismissed. Looking at the form, that's the court's full understanding of the agreement.
That's correct.
As I understand here, Your Honor, my client is ready to be sworn.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
All right. State your name again for the record.
Willie Eugene Collins.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, sir.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You had an advice of rights form explained to you
Yes, sir.
and gave permission for your counsel to sign it?
Yes, sir.
All right. Do you have any questions regarding any of those rights?
No, sir.
You understand that by entering this plea that you're giving up your rights as contained in paragraph 5, your trial rights?
Yes, sir.
All right. You understand also you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty?
Yes, sir.
July 26, 2023, at the location of 501 East Michigan Avenue in the city of Ypsilanti, Washtenaw County, state of Michigan, did you have methamphetamine in your possession?
Yes, sir.
Had you used it?
Yes, sir.
Did you know what you were using was methamphetamine?
Yes, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
People are satisfied.
The defense is satisfied, Your Honor. Thank
Court
you.
will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this case will be
10 a.m. before Judge Barr.
May 14, 2025. I'm sorry, 10 a.m. before Judge Barr.
Thank you very much.
Bond will continue. Thank you. Thank you, Mr. Collins.
I'll be in touch, Mr. Collins, okay?
Court calls the case of the people versus Chalice, Mclofflin.
Andrew Children's appearing on behalf of
An assistant public defender to not carry activity, Your Honor, on behalf of Mr. Chalice Mclofflin.
Sir, can you please state your name?
Chalice Mclofflin.
Thank you.
Judge, we respectfully request that this matter be set for preliminary examination, please.
All discovery is complete.
To our knowledge, Judge.
What the it makes sense. I don't know that they have to do a writ. You're not gonna have to do a writ on this. Bill will come get him or go get him, right?
So he's being housed there from.
I think he's being housed in Saginaw, but not by Saginaw. We're housing.
I would, we could maybe just have an extra week, just in case.
We don't have a problem with that, Your Honor.
On the 13th, all right. Discovery is complete. I will set preliminary examination will then be set May 13th, 2025, 9 a.m. before me. That'll be in person. Bond will continue.
Thank you, Your Honor.
Thank you. It's 13th. No, it's the 6th at that noon. All right. Thank you. Thank you, sir. Court calls case People versus Seth Priester.
If you ever to me,
This is
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Seth Priester.
Priester, can you state your name, please?
Seth Priester.
Thank you. All right, what are we doing in this case?
Your Honor, I'll set it for an exam.
All discovery is complete?
Yes. I believe so. I have both electronic and paper. I don't know. Just accepted the case 2 days ago. They just sent me the discovery yesterday evening. But I believe we have enough because I have.
Is all the discovery complete?
As far as the people know, Your Honor, there's a co-defendant in this case, just so the court is clear.
Co-defendant.
Also on today's docket, I have that as Devasier Hennings.
Who's representing? You're representing him?
Yes, there's a conflict in the case, so.
So you're not representing him?
I believe we're still the attorney, right?
Ms. Constantino did ask me about it earlier. She's in the court.
Where is she?
She's on today's docket. She might be with the client or in the hallway.
Might be next year.
Where is she? She's so small. You're so is she in the room or no?
No.
Okay. In speaking with her, were you under the impression she was also going to be asking for an exam?
She was not. She just got appointed, I think, like this morning, and she hasn't even gotten discovery or anything yet.
All right. Ms. Barnwell, you want an exam?
Yes, Judge.
People, other witnesses available to 6?
We'll certainly try our best, Your Honor.
Preliminary examination in person, May 6, 2025, 9 a.m. before Judge Barry.
One split second, Judge. I'm not available on that day, Judge. I'm available on the.
Why don't we do this? Let me pass this matter briefly. Why don't you go talk to Ms. Constantino, since these are co-defendants? I would rather, if we can, through some judicial efficiency, get a date that this could be heard where both defendants could be heard.
Okay, Judge.
All right. Mr. Priester, hang in there, and I'm gonna pass your case for a moment, all right?
Yes, sir.
Thank you. Court calls the case, People versus Stephen Smith.
Richmond Deputy People on all four.
Assistant Public Defender Jay Bellinger, on behalf of Mr. Smith.
James Feifels, appearing on behalf of Mr. Smith in file ending with 5506.
Oh, I apologize, Your Honor, I'm on the rest,
Yes, sir.
just in case you didn't know.
What are we doing?
Your Honor, I believe all discovery is in and we are asking the court to set these files for preliminary examination.
That is correct, Your Honor.
People have their witnesses available on the 6th.
We will try this one.
Preliminary examination in person, May 6, 2025, 9 a.m. before. Oh, joy. Okay, 12 p.m. That's before me. That's at 12 noon.
Thank you.
Bond in these matters.
Thank you very much, Your Honor.
Court calls the case, People versus Arthur Herndon.
Haley Zed on behalf of the people, Your Honor.
Folks, on the PD side, you're gonna have to make sure that that aisle is relatively clear so they can get through.
Good morning, I'm Rob Jekyll on behalf of Arthur Herndon. Arthur, state your name for the record.
Arthur Herndon.
Thank you.
You already said that? I'm sorry. Judge, today's a PCC. I met with Arthur last night. We had a long conversation. We want to set this matter for exam, please.
All discovery is complete.
Yeah, sure.
People have their witnesses available the 6th.
We'll try that, Your Honor.
Preliminary examination in person, May 6, 2025.
Judge,
Right.
can I briefly address bond?
As soon as I'm done.
Okay.
9 a.m. That is before Judge Perry. As to bond.
Judge, just very briefly, it's my understanding the bond's $50,000. This incident is between he and his significant other. I understand the situation. She came to where he was staying and an argument started. There was a no contact order between the two. He tried to get away saying there's no contact order. I'm not excusing some of his conduct, but the bottom line is, Your Honor, I just think this whole incident was provoked by the victim in this matter, who are both these parties are in juvenile court on another matter. And it escalated, and I'm just asking if the court would consider a 10% bond, Your Honor.
Response.
People have a strong objection. In this case, the victim wants the residence, which her name is the only name on the lease to get some of her belongings. She was letting the defendant stay there. When she got there, he repeatedly punched her in the face with a closed fist. He then put her on the ground and kicked her. Then put one hand on her neck and applied pressure. She had trouble breathing. He also took her phone, which she believed was to stop her from calling 911. The phone was then found on him when he was arrested. The victim was eventually able to get away from him, run to her car, where he followed her, punched the windshield damage, and also ripped the side of her car. When officers arrived, he ran from them and had to be taken to the ground to be arrested. I just had extreme concern. She was transported to the hospital for a possible concussion. She had abrasions to her chest, her forehead, her shoulder, her lip, redness all over her neck, and then bruises days later from follow-up photos. This is an extreme act of domestic violence, and I have great concern. And then he also has the child abuse case up in 22nd Circuit Court.
Judge, just very briefly, this whole incident happened over this child abuse case, Judge. And the fact of it is, she accused him when she found out, never mind, it's a long story. She took his phone. That's why he followed her, asking for his phone back. I know you've heard a lot of stuff. I'm just continuing to ask for a 10% bond. Before this had happened, before she had found out that she came to him, Judge, and the whole thing started when she argued with him. She would not leave. Granted, she was letting him leave in her apartment. She was able to live somewhere else. But again, it's not anything that he initiated, Judge.
The punching wasn't?
Judge, he was defending herself when she came at him with a knife.
Okay.
Your Honor, I also have concerns because in that child abuse case, she did report that there was past events of domestic violence that she did not report because she was scared of the defendant. So I have great concerns of their history and this.
Anything else? Motion for bond reduction is denied.
Thank you, Your Honor.
Court calls case People versus Danielle Hinton.
And is that on behalf of the people, Your Honor?
Okay. Ms. Barnwell? Really? Hinton?
Okay. How was that?
Oh, there's long lost Constantino. No, I'm telling you, Feaster said you were so short, I just wasn't seeing you. I'm just telling you what he told me. I'm telling you what he told me. Anyway. All right, that's right, Feaster, you deal with that. Okay. Hey, I'm just saying I'm just letting her know what happened. All right.
Just a record of this.
Go ahead.
Should we
Go
put my
ahead.
appearance
I
now?
called the case.
Good morning, Judge Wendy Burnwell, P42-505, on behalf of Miss Danielle Hinton, who's standing to my right.
Ma'am, can you state your name, please?
Danielle here.
Thank you. What are we doing on this case?
Your Honor, I don't have electronic discovery on this one. I have paper discovery.
We can get the discovery over to her probably by next week, Your Honor.
All right. Do you want an adjournment of this?
Yes, Judge.
All right. I'll need a green sheet. Probable cause conference in this matter will be adjourned. Okay, down.
I'm sorry.
You're not available May 6th?
Only in the afternoon, Judge. And she's out on bond.
So I'll adjourn this to May 15th. 2025, 9 a.m. bond continues. Thank you.
Thank you, Judge.
Thank you, Ms. N.
That's for the PCC, correct?
That is.
All right.
I'll need a green sheet. Form that matches your code. Court calls case, People versus Jacob, is it Brooks? Probably be mispronouncing that, but might be Brio.
That's a lot of good people.
Sherilyn Foster Tucker on behalf of Jacob Bro.
Recognize the name with the spelling. Rachel McDuffie for the people on this matter.
Your name, sir?
Jacob Allen Bro.
It's pronounced Bro?
Bro, like B-R-O.
Yeah, that's what I thought you said. That sounds, okay. Thank you.
And Your Honor, we're requesting a preliminary exam in this matter,
All right, and all discovery is complete?
to my knowledge.
People have their witnesses available on the 6th?
Your Honor, can I
Yeah.
get the following week, actually? Sorry, I'm not
13th.
available on the 6th.
People have their witnesses available the 13th?
We'll try our best. Nancy?
Preliminary examination in person, May 13th, 2025, 9 a.m. That's before Judge Valvo. Bond in this case will continue. All
Thank
right,
you, Your Honor.
thank you. Let's call the case of the People versus Jenny Lou. Oh, there she is.
Michael Getty, Assistant Public Defender on behalf of Ms. Lou, Your Honor.
Lou, can you state your name, please?
Yes, sir. Jenny Lou.
Thank you.
Your Honor, I have had a chance to speak with Ms. Blondie. There is a global resolution that I think that I haven't been able to confirm that Ms. Lou's aware of, that would resolve this and the other matter that both matters that are pending here. And I think there's already been a plea in a matter, in a misdemeanor matter. to the extent that I haven't had a chance to talk to Ms. Lou about it, I'd ask the court for a brief adjournment. I know there might be writ issues. I would be willing to do a week. I'll make sure I keep.
I can't do.
I understand, Judge.
Gonna have to be a video read.
But I would, I'll make sure I keep this case so I can go visit her, at the correctional facility and go over this with her.
I don't even, it's gonna have to go to May 15th with the adjournment. I'll need green sheets.
Oh, I'm sorry. Yes, I'll do a green sheet, Your Honor. But I'll make sure I keep this case so I go see her.
So probable cause conference, May 15th, 2025, 9 a.m. Bond will continue.
Thank you. And I'll come visit you, next week, Ms. Lou, okay?
Are you already like on your way? Because it's gonna take a while for the visitation to go through.
Yeah.
So have you got the process?
Yeah, I know the process. I'll come visit you in person, okay?
You've already started the process though, sir?
Nope, but I will be able to
Okay,
get
so
there
you
very
won't be here
quickly.
next week. You'll be here in like 2 months. All right. Okay. Thank you, sir.
All right, okay.
Thank you, Ms. Lou.
Thank you, Your
I'll
Honor.
go visit her. That's it. And I'll do those three.
Court does call the cases of the people versus Kyle Burmeister.
People, Your Honor.
James Feifels appearing on behalf of Mr. Burmeister on the file ending in 5028.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Burmeister on the remaining files, Your Honor.
Can you state your name, please?
Kyle Burmeister.
Your Honor, I believe we have an agreement of sorts with Ms. Zenda. We're asking the court to, 1, adjourn for 3 weeks, 2, modify bond to allow him to be released to inpatient treatment with a tether.
All you have to do is prepare an order. I'll sign that if it's agreed to by the parties.
Okay. So in that case, then we're asking, I believe 3 weeks would give us some time to hopefully negotiate a resolution.
Probable cause conference, May 15th, 2025, 9 a.m. Bond will continue.
Gotta give him a call. We can have somebody help you call them.
I did. So all the other. Pretty good.
Thank you, Your Honor.
We'll get
Thank you.
here in the next day or so
Constantino,
Okay.
have you talked to
on these 2 files.
the one that was for, the last person finished my sentences, no longer around.
Yeah, we'll have.
Okay, so you guys are ready on that? If I call, okay. Thank you. Court calls case, people versus Brendan Chrysler.
Your Honor, can we pass that a moment? I'm still waiting for him. He had some car troubles. Thank you, Your Honor.
Court calls case, people versus Eddie Gardner.
Richard McGuffin for the people.
What's her other case?
Good morning, Your Honor. Christina Costantino appearing with and on behalf of Mr. Gardner, who is present and standing to my right. Mr. Gardner, please state your name for the record.
Eddie Gardner.
Thank you.
Judge, this is a date and time set for PCC. It's my understanding that discovery is complete to my knowledge, so we would be asking for a preliminary exam.
People have their witnesses available to 6. Preliminary examination in person, May 6th, 2025 at 9 a.m. before Judge Perry.
Thank you very much, Judge.
Thank you. Bond continues. Court calls the case of the people versus Michael Hill.
That was for the P727, right?
James Feifels on behalf of Michael Hill, who is approaching.
Hello, Your Honor.
Hello.
State your name, please.
Michael Wayne Hill.
Your Honor, this is a first PCC. I'm still awaiting discovery, so I'm asking for an adjournment to May 15th so I can obtain that and review with my client.
You need all the way to May 15th?
It'd be helpful, just since I haven't received anything yet, so if the court can.
May 15th, 2025, 9 a.m. Bond continue.
Thank you very much, Your Honor.
Court does call the case, people versus Julia Sinski.
That's the one for the people.
And James Fifelsky on behalf of Ms. Sinski. Can you state your name, please?
Julia Sinski.
Judge, we're still trying to get to the bottom of some discovery, whether it exists or not. But I've been asking, and I know the prosecutor's office has been trying to get it from MSP, but we don't have it yet. So if we can do one last adjournment for 3 weeks, I'm hoping they produce or they tell us that it doesn't exist, and then we can move forward.
Just so you're aware, Mr. Pavelski, and I know you're aware of this, I don't set it for attorney's convenience these dates. May 15, 2025, 9 a.m. bound continued.
Thank you very much, Your Honor. Talk to you soon. I'll give you a call and say or something.
Court does call the case, People versus Devin Gibson.
That's your honor, please, Brandon Bird on behalf of Devin Gibson, PA 3734.
Good afternoon, or good morning.
Good morning.
Your name, sir?
Devin Gibson.
Thank you. All right, what are we doing?
We'd like to set this matter for exam, Your Honor.
All right, you have all the, all right, you have all the discovery, sir?
Yes, Your Honor.
All right. People have their witnesses available to 6. All right. Preliminary examination in these matters will be set in person, May 6, 2025, 9 a.m. That's before, at 12 noon. That's before me. Thank you. Esteban.
It's come to my attention that the defendant has made 80 calls to the victim since the arraignment using his pin and other pins. In these calls, he knows the victim, but at first they talk about the crime that occurred here and he apologized. Also in these calls telling her what to do and say in court. So I have great concerns, given that he's contacting the victim from jail, who would ask his phone privileges be revoked.
Anything you'd like to say in that regard, counsel?
No comment, Your Honor.
All right. Given that his monetary bond will continue, his phone privileges are hereby ordered revoked. All right. Thank you.
Thank you, Your Honor.
Court calls case People versus James Valore.
Good morning, Your Honor. Laura Willenberg on behalf of people.
Good morning again, Your Honor. Christina Costantino appearing on behalf of James Valore, who is present via Zoom. He is coming from the KPEP facility. Mr. Valore, if you're on Zoom, could you ask them to unmute you and state your name?
Pardon?
We have a dial.
There's an individual who's dialed in. Last 4 digits or last 3 digits are 465. Can you hit *6 and state your name?
James Valore.
All right, that's it.
So just as date and time set for PCC, at this time, we would be asking to have this matter set for a preliminary examination. And given the nature of how discussions with the people and I have been going, we would ask if the court would consider setting this out a ways, perhaps to the end of May.
That's correct. No, second.
Like the very end of May, like May 27th would that be good?
That would work for the defense.
And discovery is complete. So set preliminary examination in person. That would be May 27th, 2025, 9 a.m. before Judge Fresh Hour.
Thank you very much, Judge.
Continued. Thank you. Have they figured out what they're doing on their co-defendant so I can get Mr. Brewster?
I believe they're ready. I can give you, they have one other individual here that I could give them Hennings.
Court does call the case, People versus Kim Perkins.
Good morning, Your Honor. Tim Sachs on behalf of Kim Perkins.
Your name, ma'am?
Kim Renee Perkins.
Thank you.
Your Honor, this is a date and time for a PCC. We're asking for a preliminary exam date. I do have written and video discovery.
You have all the discovery, okay. People have their witnesses available the 6th.
I believe so. Well, we'll try our best.
Preliminary examination in person, May 6th, 2025 at 9 a.m. before Judge Perry.
And Your Honor, if I may make a bond reduction motion.
Go ahead.
Your Honor, I'm asking for the bond to be reduced to a PR bond. Miss Perkins is here on an allegation of assault and battery with Bridget Williams, her daughter. What I've seen so far in this, at worst, this was a mutual combatant. Miss Perkins' top was torn off. She actually called 911 first, and then she wound up being arrested. The alleged victim also called 911. So this is not a foregone conclusion that she was the aggressor or would be a further problem. She has secured housing with her other daughter in Port Huron, so she does not need to go back, except for one time with a police escort to get her wallet and a couple of clothes, and she assures that she will be able to attend all future hearings.
Response.
Your Honor, I want to be clear, this is not a matter of assault and battery. This is a case of alleged felonious assault where the victim, Ms. Perkins' daughter, alleged that Ms. Perkins argued with her, fought with her, and tried to stab her with a knife, as well as scratching her face in the course of that incident. I appreciate that she has somewhere else to live. I would
hold on a second. Do they live together?
The victim in this case was apparently allowing Ms. Perkins to stay with her at that residence. And Ms. Sachs.
Okay, so they live together. All right, go ahead.
I would ask that bond continue. If the court sees fit to release her, I would request that she have a hot zone tethered to this location. Additionally, I believe that arraignment, there was a request made, I don't know if there's a check order on this file. Ms. Perkins has a very long history of drug and substance abuse related offenses and convictions. At the time of this incident, she was highly intoxicated and incoherent as well. So I would be requesting that she was tested with all substances possible with some sort of overlay or other device as well. If she would be.
Anything else, Ms. Sachs?
No, Your Honor.
What I'm going to do is I'm going to grant the motion for a bond reduction. I'm going to reduce her bond to a $2,500 personal cognizance bond. I will also indicate that the defendant is to report to community corrections upon her release for placement on a GPS hot zone tether. Since she's going to be set for exam, I'm not going to order testing at this time.
Okay. Thank you, Your Honor.
Court does call the case, People versus Kadavian White.
I'm here.
Christina Costantino appearing on behalf of Mr. White. Mr. White, can you please state your name for the record?
Kadavian White.
Have a camera, sir? Thank you. All right. What are we doing on this case?
Judge, this is a date and time set for PCC. We would be asking for a preliminary exam in this matter. Discovery is complete as to my knowledge.
People would have their witnesses available the 6th. Preliminary examination in person, May 6, 2025 at 12 p.m. That's before me. Bond will continue.
Thank you, Judge.
Thank you. Court does call the case of People versus Devasier Hennings. If I'm saying that correctly. And I will also call the case of Seth Priester.
Christina Costantino on behalf of Mr. Henning. Mr. Henning, can you state your name for the record?
Devasier, Hearnen.
Good morning, Your Honor. Wendy Barnwell, once again, P42505 on behalf of Mr. Priester. I don't see him on the screen. I know he's in.
Right.
now.
Could you unmute and then state your name, Mr. Priester?
Seth Priester.
Oh, there.
Thank you. All right. What are we doing?
Judge, I was just appointed on this matter either late last night or this morning. Given that I do not have any discovery at all, actually.
So you're ready to go.
I'm ready to go.
Yeah.
Hey, you know what? I always ready. But given that, to ensure I'm representing my client to the best of my ability, I would be asking for an adjournment of the PCC so I can obtain discovery and review it with my client.
Counsel?
Yes, Your Honor, I will go along with Sister Counsel and I believe we'll return on May 15th is our proposed date.
Oh, so you're picking dates.
Just only because I got it from you for the other case.
Yeah, I know, but again. Make it 30 out there, but Ms. Constantino, will the 15th work for you?
Yes, Judge, I can make that work.
Probable cause conference, May 15th, 2025, 9 a.m. Bond will continue. I need green sheets on these, please.
Oh, I'm sorry, Judge, I do have it right here. Judge, would the court consider hearing a bond request, a bond reduction request?
I will always hear it.
Thank you, Judge. I'm told my client's bond is currently set at $250,000. We would be asking if the court would consider a lower bond, perhaps $100,000, 10%, with a 10% provision. He is 18 years old. He would be, prior to his incarceration, he had employment lined up at JMB Temp Agency. We are hopeful that he would be able to return or start that employment. He was also enrolled in an adult education GED course that he could continue. Should he be released, he would reside with his mother in Ypsilanti. She's very supportive of him. He has a significant other and a 2-year-old child that he does provide support for. It's my understanding that he does not have any prior adult criminal history, and he would be able to follow any and all no contact orders.
Response from the people.
I believe it's correct that he doesn't have any adult prior history. This is the case with Mr. Priester is currently a juvenile charged as an adult. The history that I do see is that he apparently.
Mr. Henning.
This is your.
Mr. Henning.
I apologize. Sorry about that. They're called together, I guess. As far as Mr. Hennings is concerned, Your Honor, obviously the circumstances of this matter, which would be a co-defendant in the armed robbery case, are concerning on their own. I will leave it to the court's discretion. I did want to ensure that if there's a no contact order on this case, that it does include Mr. Priester. I apologize for misspeaking earlier because of the cases were called together, but Mr. Hennings does not have any adult history as was stated. His juvenile history does obviously include, not obviously, but includes some counts that were adjudicated in that manner, and he has had some felony charges that were pretty serious, I think, resolved with misdemeanors, being unlawful breaking and unlawful use of an automobile, breaking and entering, tampering with the tether. There's quite a bit here. So Ms. Constantino was correct that there's no adult history, but there's quite a bit of juvenile history here as well. That's concerning. Leading consistently going from 2020, looks like roughly 5 or 6 cases up through 2025 was dismissed attempt charges in terms of activity.
Anything else?
Nothing, Judge. I would just suggest that $100,000 bond would, I believe, would account for even the juvenile history that's been mentioned.
I will, on Mr. Henning's case, I will reduce his bond to 100,000. I will not do 10%. It'll be 100,000 cash surety.
And may I address one for Mr. Priester?
Apparently, yes.
So, Judge, no, I am pretty sure that, well, I'll rephrase it. I was about to say something. But my client's mother is present in the courtroom. He has been living with her. I know that he was attending a program, I believe, several days in the week over here at Community Corrections, Judge. I do believe that the bond is excessive. And I'm pretty sure that this court understands the concept of a presumption of innocence if the bond is excessive. Thank you.
Response?
So returning to the argument that I was beginning to make earlier, Mr. Brewster, in terms of the juvenile history that we have, obviously still juvenile state charges in the Belcher armed robbery case. It looks like there were 5 previous petition requests in the past year and a half. Unfortunately, those were denied due to some evidentiary issues, I believe. It looks like on the most recent case we have with him, which is the 2024 matter, he did have a plea for home invasion first, UBAA, receiving and concealing a motor vehicle, and financial transaction device theft. So I think we have a plea after that on a separate case for another receiving and concealing stolen property.
Are you saying those are all juvenile adjudications?
It appears to be so, yes. I think this is the first one where he's been charged in adult, if I'm not mistaken. The allegations in this case are not only armed robbery, apparently, that between the individuals involved in this, the victim was pistol whipped in the face. So I understand that this is a juvenile situation, but obviously these allegations and offenses are very concerning. So I would request that.
Anything else?
Your Honor, as to cases that don't meet in the evidentiary threshold, so we still have a constitution that's very active now. And so I would ask, and this court knows there's a presumption of innocence to this. I don't believe that counsel has brought up anything that's violent or anything of that nature. I'd respectfully ask that this court lower the bond significantly.
In this case, so those previous juvenile adjudications in this case, which I think are a distinction between his co-defendant, I am going to decline to reduce the bond in this case. Motion for bond reduction regarding Mr. Priester is denied. Bond will continue.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Court calls case People versus Julian Ward. Yeah.
Christina Costantino appearing on behalf of Mr. Word. Sorry, Drew.
Julian Ward, present.
Judge, this is a date and time set for PCC. At this time, we would be asking to have this matter set for preliminary exam.
Okay, that's not. Just coming.
So this is, the bonders, you wrote 2 emails, one asking for her bond back, the second one saying that she did not respond back. So
And she did not.
correct, yeah, I think that's on the side. Yeah. So I don't think.
So you're looking for a preliminary examination in this case?
Yes, Judge.
And you said discovery is complete.
To my knowledge, it is.
People have their witnesses available to 6.
That is fine.
Preliminary examination in person, May 6, 2025. 9 a.m. before Judge Perry. And we'll continue.
Thank you, Judge.
Thank you.
Thank you.
Thank you, sir. Court does call the case of the People versus Stefan Scott.
Morning, Your Honor. Sam Bernstein with on behalf of Mr. Scott.
Your name, sir?
Stefan Scott. You're asking for a brief adjournment to review discovery.
Probable cause conference, May 6, 2025. That's a Tuesday, 9 a.m. Bond continue.
You can't move forward without all discovery. Thank you, Your Honor. Appreciate it.
Court does call the case People versus Marica Philpot.
Mike Gaddy, Assistant Public Defender on behalf of Ms. Philpot.
Philpot, can you state your name?
Me?
Yes, ma'am.
My real name is Teresa, but I do go by Marica.
Okay. We'll work with that. Okay, what are we doing?
Your Honor, I have to ask the court to adjourn this matter. I do have a green sheet. I did seek to visit Ms. Philpot yesterday. She wasn't up for company.
Okay.
If I could approach.
Yes.
But I will go visit her again for the next hearing.
All right. I'll adjourn this matter to May 6, 2025, 9 a.m. That's a Tuesday. Continue.
And Ms. Philpot, I'll come visit you, but make sure you come up and see me, okay?
Okay.
Thank you.
All right. Thank you, Ms. Philpot.
Yeah. What the hell?
But that's not the case.
Hold on, let me get you.
Clerk calls the case, People versus Anthony Taylor.
Morning, Your Honor.
Morning, Your Honor. James Fifelski on behalf of Mr. Taylor, who's to my right. Please state your name.
Anthony Taylor.
Thank you.
Judge, I believe all discovery is in. We are asking the court to set this for preliminary examination.
Your Honor, may we approach briefly?
Why? Well, who's coming up?
Myself and Ms. Willenberg.
Okay, if Ms. Willenbring's coming, then yes.
I do.
You may come up. All counsel has indicated all discovery is complete in this matter. And we were discussing dates. I'll set preliminary examination in person, June 3rd, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Bond will continue.
Thank you, Your Honor.
Thank you.
I'll stop by and chat with you. I'm requesting. I'm trying to stop by and talk to you.
Huh? So cool. It's one of the ones with the big flap. It's gonna be, because you like those, so. You don't know? Oh, so if it shows up, you might like run out. Never mind. We'll talk later. Let's call the case. People State of Michigan versus Todd Ammerman. That would be fun.
I love this job.
Good morning, Your Honor. Jennifer Douglas for the People, P72748. And good morning, Laura Yagi, Assistant Public Defender, sort of with, but mainly on behalf of Mr. Ammerman. Your Honor, Mr. Ammerman is on Zoom. I was just trying to be in a breakout room with him. My understanding is he's not in Your Honor Zoom. He's in Judge Freshour's Zoom.
Oh, that works.
It does not.
I know.
I don't know what's going on. I was,
Okay, all right, it's okay. Yeah. So what do you need to have happen? You need him to get to my Zoom.
So, Your Honor, I was going to ask for an adjournment anyways. I did fill out a green sheet. I would ask for an adjournment and to allow us time to get him in the right place and to get him here. The Freshour staff is not able to communicate well with him to get out of their Zoom.
What's that? He won't get out of there.
They tried to send him. But
So have you talked to him about signing into this Zoom?
I have not. I have attempted, but I have not been successful in.
Okay, because Judge Freshour staff, I was just informed, are trying to communicate with him to get him to sign into the right Zoom. It's not going well.
Yeah, that does not surprise me.
Oh, well, okay. Appreciate your candor.
I really don't know what is going on, but
Ms. Yagi, I'll let you out the hook.
Thank
Is there any objection from the people to the brief adjournment?
Your Honor, there's no objection. I don't have any information that suggests that we're doing anything.
All right. I mean, he theoretically, I guess, is next door, so he. All right. Let's wait 1 week out. Can you explain this to him in a week?
I will do my very best.
All right. Probable cause conference, May 1st, 2025.
Thank you, Your Honor.
You're welcome. Ms. Yagi. Court calls case People versus Quinton Williams.
Alexander, on behalf of people, Your Honor.
Morning, Your Honor. Wendy Burnwell, P42-505, on behalf of Mr. Quinton Williams.
Your name, sir?
Quinn Williams.
Thank you.
Good.
Okay, what are we doing?
I'm requesting an exam, Judge,
All discovery is complete?
upon information and belief. I believe so.
What's that mean?
I have electronic as well as paper discovery, Judge.
You're not available the week of the 6th, right?
One split second, Judge.
Well, you just looked it up before and said.
Yeah, I have to look at the actual thing.
Go for it. I was trying to be nice.
I'm available on the 5th.
Okay. But we won't be here on the 5th.
Oh,
Well, I'll be here, but we won't be holding exams on the 5th.
okay.
It's the 6th or the 13th?
One split second, Judge.
I know the answer. It's gonna be the 13th. Because you're not available the 6th, because we've already gone through this. But that's okay, I'll wait.
Donna, can you guys do it on a Friday?
Can I do what?
I'm available on the 9th of May.
Okay, good.
I mean, jury trial on the 13th,
Okay,
so I don't want to call that.
we do exams every Tuesday.
Okay. The 20th. Come on now.
People have no objection to that.
When I'm available, guys, I'm in trials.
Preliminary examination, May 20th, 2025, 9 a.m. That's before, please. Judge Bar.
Available there.
We'll continue. Thank you.
Okay.
Thank you.
All right.
Court calls the case, People versus Cody Jolly. It's in Zoom.
Andrew Childers appearing on behalf. Yes. Did you ever have any luck? Oh. No. I'm sorry, no.
Mr. Jolly?
Yeah.
He's unmuted. Well, he's muted, so I can't. Mr. Jolly, can you hear me?
Jolly.
I know he hasn't been up. Is he responding at all to us?
No, Your Honor, he's just sitting there.
Okay. What are we gonna do on this?
What I can tell the court, there was discussions between myself, Mr. Jolly also has cases pending in 15th District Court. Prosecutor there has spoken with jail staff about possibly getting a petition if the CMH worker in the jail. That does not appear to be something that can be done. What we then tried to do, or are in the process of trying to do, is work out a plea with Mr. Jolly. Mr. Chabalowski, who's the 15th District Court prosecutor, and Mr. Gaddy just kind of going as standby counsel, attempted to go to the jail and speak with Mr. Jolly, I believe last week or the week before, but there was an issue with actually getting him to come up and speak with them, so they weren't able to facilitate any conversation about any sort of resolution. Actually,
Your Honor, Mr. Chablowski and I, Mike Getty from the Public Defender's Office, Judge Perry he has not asked for standby counsel, but just in case he changes his mind while he's talking to the prosecutor, she asked if I would go, and I agreed. And we tried to go down. It was not a good time for the jail, so we're planning on doing it later this week, and we haven't had a chance. We're hoping to go tomorrow. Okay. So we did attempt to see him, but he didn't refuse us. But I mean, to be candid, he's refused everything else.
So what do you wish for me to do today?
I'm merely a reporter in this.
Yeah, I know, I got you. Well, until we can figure something out, I mean, this is sort of at a standstill. I mean,
I guess at this point, we'll give them another chance to see if we can have some sort of conversation.
That's fine. So what I will do, I think, haven't we sent him for comp already?
Found competent, although the thing that struck me about that is that CFP relied on the earlier finding of competency, having not seen him for all.
Correct. So, all right, I'll adjourn the probable cause conference in this case to May 22nd, 2025, 9 a.m. Bond continued. All right, thank you. All right, we're all set. Thank you, Lee.
Thank you.
Court calls the case People versus Byron Blair.
Pass along to the people.
Honor Alexis Plume, appearing with and on behalf of Mr. Blair, who is approaching. And Mr. Blair, could you state your full name?
Byron James Blair. All right. I have before me a plea form. Indicates he would be pleading guilty to the charge of retail fraud, second degree, the 1-year offense. Upon a successful plea to that charge, count 1, retail fraud, and the first would be dismissed.
Yes, that is correct, Your Honor. I have gone over that offer with him as well as an advice of rights, which should be in the file as well.
You have it. All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Byron Blair. All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree.
Yes.
That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that, sir?
Okay.
Okay. Understanding all of that, do you still wish to plead guilty?
Yes.
Are you sure that's what you want to do?
Yeah. You scared me, like, who is Valore? I'm sorry, you like, are you sure?
Like, who is Valvo?
Talked about the
Oh, she's the
judge
chief
in
judge of the 15th
15th
District Court.
in downtown Ann Arbor. So remember, Judge Simpson is not going to sentence you.
Oh,
You're gonna be
I
sentenced
got you.
Okay, what do you got me for? What are you telling me?
No, I understand what you were saying. Like, the way you said it was like I was just imagining the executioner or something. Oh, like, I was scared for a minute. Like, who is Valvo?
Oh, so you thought Judge Valvo was an executioner?
Yeah, like you know, it's not gonna be me.
No, I'll call her today and let her know.
No.
I mean, I just to share that information.
No, sir. I'm sorry. Okay, I'm sorry.
Oh, and of all the judges. Say that. Okay, you're clear now. I'm just taking your plea. You would have a right to have me sentence you, but I need you to understand that this case is set not to be sentenced, that I would not do the sentencing.
Okay, I got you.
You got it?
I got
you. You okay with that?
Yes, I'm cool.
Okay, so understanding all of that now. Do you still wish to plead guilty to the
Yes, sir.
charge? You do?
Yes, sir.
All right,
Yes,
and
sir.
to the charge of retail fraud second, how do you plead?
Guilty, sir.
All right, now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, yeah.
All right, you signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, yes.
You understand you're giving up your right to appeal of right.
Yes, I did.
Are you on probation or parole?
I just got on probation on the 11th in Detroit. Yeah.
So you're off. You're not under the jurisdiction of any court at this time.
I'm on probation. No,
He's on
no, I
probation out
just
of
took
Wayne
probation.
County.
I'm trying to get all of my stuff together. I've been on.
I don't know what that meant.
Counsel? He was not on probation or parole at the time of the offense. He has now recently been sentenced to probation.
Yeah, for old case, 2020 or something.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
Nope.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, I am.
Of your own free will? And because you believe that you're guilty of this offense?
Yes, I do.
June 1st, 2024, at the location of 303 South State Street, City of Ann Arbor, Washtenaw County, State of Michigan. Tell this court what you did on that date involving the Emden store that makes you believe that you're guilty of this.
I exited with some items, but they got returned back, some Jordan shirts, a couple hats or something like that.
Okay, so you went into the store.
Yeah, I exited. Yeah, I didn't pay for it.
Okay, I got it. So you went into the store, you took property that the store had for sale.
Yes.
They were open to the public.
Yes, yes.
And you tried to walk out of the store
Yes, I
without
did.
paying for that.
Yes, I did.
Is that correct?
Sir.
All right. And you didn't have anybody's permission to do that?
No, I didn't have nobody.
All right. Was the value, is this on value or prior?
Value.
All right. So was the value total of the property that you tried to take out of the store, was that in excess of $200?
Yes, it was.
All right, counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is also satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered through 15th District Court probation. Sentencing will be May 20th, 2025, 9 a.m. before Judge Valvo.
Okay.
Judge Valvo. Not execution.
I know.
All right.
And Your Honor,
I'm going to call her though.
may I briefly address bond?
Yeah, go ahead.
Okay. Your Honor, we're asking the court to consider a personal bond for Mr. Blair. The reason that bond is set high on this file is because there were a couple of failures to appear in the past. Mr. Blair has explained that those failures to appear were due both to him being in and out of the hospital. He does suffer with congestive heart failure. And that's one of the reasons he would like to be out of custody to continue his medical treatment, as well as going back and forth between this county and the Wayne County Jail. He has now resolved all of his cases in Wayne County. I don't see that he has any out-of-county holds. He was recently placed on probation in Wayne County, so he's a little worried about picking up violations and not getting the programming aspects of his probation completed because of being in custody here. If he was released, he would be going back to the Delanis Center to live for right now. He is participating in their Pathways program. He has a caseworker there, as well as a CMH caseworker that he's been seeing in the jail. He did provide me with their contact information. And he does have a phone, so we'll be able to reach him. He just wants the court to know that he did not mean to miss his court dates, and would like the court to consider allowing a personal bond. His other cases in this county are retail frauds. They all have very low bonds set right now, just so that he was getting credit while this case was holding him. I do believe his other cases in 15th.
No,
He-
no.
he would get a-
Please go on.
I'm sorry, I do believe his other cases in 15th would revert to personal bond if he was given a personal bond on this case.
Any response?
Your Honor, this is one of 5 pending cases, only the defendant right now, they're all regional squad. Yeah, I'm concerned with, I understand he's saying he was sick, but he did have, I think, at least 3 bench warrants in this case. So I'm gonna request that bond continue at least until the time of the TSIR.
I tried it. I was in the hospital. And then one time y'all pulled it back because y'all had me mistaken. Oh, can I talk?
You were in the hospital, you were going back and
called
forth
up here.
between Wayne County and here.
I called your office up here and I was known that it was a mistake because y'all had me down as being in custody doing
Y'all, that's me.
Not y'all, okay.
Go ahead, no, I'm listening.
The Washtenaw County court system, right?
Oh, that big y'all.
Okay, yeah. The big
Okay,
y'all.
yeah, okay, go ahead.
Okay. It was a mix. Okay. One incident, I left here. I wasn't released from custody because I was picked up by Wayne County. I was held there, didn't Zoom. So when I get out of Wayne County on tether, I had a warrant for you instantly there.
Acting really, why are you nodding like all this is? No, go ahead.
Like this is crazy. I just been ping ponging back and forth between Wayne County and Washington. So while I was in Wayne County, they never zoomed me to come here. So when they kicked me out on tether, when I paid bond, I get out on tether, right? They say you have a warrant in Washtenaw County. For what? For not going to court. I said, okay. I come out here to Washtenaw County. I ended up in custody trying to figure out how to turn myself in. I come back up in here, y'all set me another court date. Now guess what
Y'all,
happened?
that's it. Big y'all.
The Washtenaw County court system.
Okay, go ahead.
Okay, now this is what happens the next time. I'm on tether. They cut my tether off because I was in here so long waiting to see you that my tether went dead. Now I got to go back to the new Wayne County jail, which is like backed up 2 to 3 weeks just to get out on tether. So by the time I get back out on tether, they had me another paper again to say you would now have another warrant in Washtenaw County for missing court. I'm ping ponging back and forth. When I just got my tether off on the 11th, they called y'all Washtenaw County.
Y'all, all of us.
They called the courts up.
Okay.
They let y'all know.
I'm just trying to
because you gotta have a lien. You gotta have a lien when you get sentenced to probation time. So I went in prepared to come in, right? And this and that. They told me, advise or release, take care of it when you get up here. So I got up here. I got with my caseworker. This, that. I was supposed to be going to this transitional housing stuff set up. This and that. I made sure I had my house stuff set up here first. And then now I'm trying to see what you.
If I give you a PR, will you stop?
If you don't send me back to Detroit and ping pong me, yes. Whoever said that, yes. That's the first time I ever been able to talk.
No, I don't believe that for a minute. You are too good at talking. That to be your first time.
All right, sir.
Well, he's got other holds that are going to hold him in, but if you're asking me to reduce this bond, it right now it's at 1,000 cash or surety.
No, they said that the bonds that they gave me that it will convert into.
So he wants a personal bond on this case because that would make it a lot easier to get personal bonds on his other Washtenaw County.
Oh, I got
cases.
it. I was just ready to rule and he started talking again.
I think he did a great job.
He did. He did a fantastic
Better than
job
me.
for the last hour.
Yes, Your Honor.
That's what.
Yes, there were other holds, I said yes.
And
4 other cases that have.
4 other cases, that's what you were saying.
Yeah.
Before we.
And I'll just put the course of information to you. I see a 2019 case, 2022 case, 2023 case, and a 2024 case.
Grant the request to reduce his bond. They'll set his bond at $1,000 personal recognizance bond.
Thank you. You're welcome. Thank you.
Take care. And I've already sent a message to Judge Valvo. She's waiting for you. All right, take care. Bye-bye.
All right, yeah.
Court calls the case People versus Deshaun Clifton.
Your Honor. Assistant Public Defender Dodd will leave on behalf of Mr. Clifton. And Your Honor, we're going to be requesting an adjournment. Mr. Clifton, can you state your name?
Deshaun Clifton. Thank you.
And Your Honor, we're going to be requesting adjournment of the PCC in order to receive some outstanding media discovery of the dash cam and body camera. I have prepared a green sheet.
Okay, you have a green sheet?
I do.
Objection. Probable cause conference will be adjourned May 15th, 2025, 9 a.m. Bond continued.
Your Honor.
Thank you. Case People versus Zachary Bruno.
Richard McDuffie for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bruno. Mr. Bruno, will you state your name for the record?
Zachary Bruno.
Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
All discovery is complete.
To our knowledge, yes.
People have their witnesses available to 6. Pardon?
We will try it.
Preliminary examination in person, May 6th, 2025 at 9 a.m. before Judge Perry. Bond will continue.
Thank you.
All right. Thank you.
Oh, that I passed it? I thought he was on his way. Court does call the case People versus Antonio Cornelius.
And good morning, again, Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Cornelius, who's approaching. Can you say your name for the court?
Antonio Cornelius.
And Your Honor, we would respectfully ask for this to be set for exam.
You seem to be doing better than your last case. Okay. Discovery is complete.
To our knowledge, Your Honor.
All right. People have their witnesses available on the 6th. Preliminary examination in person, May 6th, 2025. 9 a.m. Sorry. 12 p.m. 12 noon before me. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Gregory Davis.
Richard McDuffie for the people.
And that is me again, Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Davis, who is approaching. Mr. Davis, could you state your name for the court?
Gregory Davis. Thank you.
Your Honor, this has been postponed a couple times. And we were trying to see if we could consolidate it with the case that we were told is upcoming. That case has not been charged or authorized. So we are asking for an exam date at this time. In terms of discovery, I did request the 911 call back in March. We don't have it, but I don't want to keep waiting. Mr. Davis is held in jail on this, and so I can't keep adjourning it just for that.
People have their witnesses available to 6.
We will try our best, and Michelle, yeah, that was sent that 911 call to you a few weeks ago, so I will check on that again.
Thank you.
Preliminary examination, May 6th, 2025. 9 a.m. before Judge Perry.
Your Honor, may I briefly just address bond?
Briefly.
Okay, this is one of two cases that are holding him, or he has 1 or 2 cases out of 14B. One is just traffic, one is DV. He has done over 50 some days on the DV 14B case. He was set for final settlement tomorrow, but then he was removed from the docket because they didn't know he was in jail. Somehow he had just been sitting with that outstanding warrant without being arraigned on it. He is now set to go to 14B on Monday. And obviously, I don't know what they're going to do, but I would ask if the court would consider lowering his bond. It's a $5,000 cash surety right now. I would ask for a 10% provision to be on there, because just in case they do give him a personal bond in 14B, which I'm very optimistic that they will, because he's done so much time on that case as it is. He has a job at Cracker Barrel waiting for him. And just to be candid, Your Honor, I've been representing him. This is, I think, our third PCC together. I've met with him several times. He's met with CMH in the interim. Personally, I've noticed a difference. When I first met with him, he was very loud. He was agitated. We had a really great conversation, and he actually thanked me for pointing out to him that he was so loud. He's met with CMH. He's been so genuinely reflective since. And I really mean that. I don't say that, as Your Honor knows, I don't say that about all clients. So I think he's really done a lot of reflection. And so I would ask if the court would consider a 10% provision.
Response from the people?
Your Honor, I can't speak to what 14B is going to do. Obviously, Mr. Davis's case, the issue that we have with Mr. Davis, I think, is primarily the fact that he had a case pending for exam. That case did end up being dismissed at this point because we had a witness that was not available, an officer that was going to be gone for quite some time. When one of Mr. Davis's cases was pending, we had a new incident where he showed up to that victim whose mother's house and was trying to get in. Essentially, we have the NDOB on that case. We have some bond concerns, obviously, there. The domestic violence case, I don't believe it's related to some of these other incidents. The new warrant, I've heard, we do not have a response back on that further yet, but that is a completely unrelated UDAA allegation as well. Mr. Davis, should he be released? I'll leave that to the court's discretion. I do know that Mr. Davis has, I can appreciate that Mr. Davis has been improving. I think that maybe because he's had a chance to essentially detox. I know that he was under the influence of apparently narcotics, I think, at the time of this incident. And Mr. Davis has a warrant out of the 35th District Court for controlled substance possession. I don't know if he is aware that that is out there. He was arraigned on that on November 10th of 2024. And that bench warrant, was issued a few weeks after that, so November of 2024. So if he were to be released, I don't know if there's a testing order on this file. We'll be requesting that, obviously, in his history. And hopefully he'll be able to get that one as well.
Your Honor, may I respond very briefly? I just have to clarify something.
Okay.
Ms. McDuffie stated he went to the victim's address. He was on house arrest there. He was supposed to be there. So this is not a case where he returned to the victim's address against the court order. He was literally on house arrest there at the address with his mom, who they're saying is the victim. But he was supposed to be there. So I just have to clarify that for the record.
Are we done?
Yes, Your Honor.
Okay, I'm gonna grant your request.
Thank you.
Its bond will be set at 5,000. I'll give a 10% privilege on that. Thank you.
Thank you.
Are there any no contact orders on this matter? I'm not sure what Ms. Jackie was referring to. We have a contact order with it. So
That is not true. He had a consensual contact order. We have to be clear for the record. It is not true that he had a no contact order. He was on house arrest there at his mother's address. He was allowed to have contact with her. He was supposed to.
Is that Ms. Freeman?
It is Martha Freeman, yeah.
Okay, what I have is, I have a no contact with her at this time.
With this case, not with the other case. Okay. Thank you.
Thank you for your concern.
Thank you. Okay,
Okay. Thanks. Court calls the case, People versus London Dottery. Oh, boy.
Torshell Feaster, First Assistant Public Defender, on behalf of Mr. London Dottery, who's approaching the podium.
Did you apologize to Ms. Constantine?
I did, Judge.
Did
She
you?
graciously forgave.
Did she accept your apology?
She said she did. I
She
pray
said
she
she
did.
did?
Yeah, she said she did.
Okay.
So I hope. I hope she really did. She said she did.
Okay.
Thank you. State your name, sir.
London Battery.
Thank you, Judge. I have submitted a green sheet. We're requesting a 3 or 4th adjournment. We are undergoing mitigation, and I believe we're also investigating a potential motion.
How much time?
3 to 4 weeks, please.
Wow.
Whichever one is better for the court.
No. I see, I see how you snuck.
Not picking my date. Just.
I know. I saw how you did that.
May 20th,
Thank you, Judge.
2025. 9 a.m. bond will continue.
All right.
Oh, May 20th is 22nd.
The 22nd.
Yes.
Thank you, Judge.
Thank you, Miss. Court calls the case of the people versus Brian Gerard.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Gerard, Your Honor. He's approaching.
Your name, sir?
Brian Gerard.
Thank you. Okay, what are we doing?
Your Honor, I've had a chance to speak with the prosecutor and speak with Mr. Gerard. He'll be waiving his exam this morning. Oh, date, it's 24th. I have explained to him he has an absolute right to that exam. I believe the people have agreed not to habitualize this matter. 24th.
Sir, you're waiving your right to preliminary examination? Gerard, you're waiving your right to a preliminary examination?
Yeah.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right?
Yes, Your Honor.
Okay.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we'd waive reading, stand mute, ask the court to enter a not guilty plea.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for May 5th, 2025, 1:30, Judge Hammoud.
Your Honor, I believe he has other matters set with Judge Hammoud on the 12th. I don't know. Well, they'll just move him if he does. Thank you.
You're informing me of that because of why? You want me to give you the 12th?
I hate dead air.
What?
I hate dead air. No, the 5th is fine. Judge.
Okay, good. Thank you. Fine, continue. I cannot figure everything out. Court does call the case, people versus Gervais Drake.
And then I have people.
Assistant Public Defender Jay Belcher on behalf of Mr. Drake, who approaches, Your Honor.
Your name? Gervais Drake.
Your Honor, we're just asking to set for exam at this time.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available to 6.
We'll do our best, Your Honor.
Preliminary examination in person, May 6, 2025, 12 noon. That's before me.
Thank you, Your Honor.
Thank you. Bond continued. Court does call the case, people versus Haley Gregg.
Jennifer Douglas for the people.
Oh, she was still here. I
I'm
told you.
back. Couldn't get rid of me that easy. Christina Costantino appearing on behalf of Haley Gregg.
Your name?
Haley Gregg.
Judge, this is the date and time set for PCC. I was just appointed quite literally about 10 minutes ago. So given that, I would be asking for an adjournment of the PCC.
Is this the only thing holding her?
No, Your
Sorry.
Judge, it was my understanding that her only other hold was a Melvindale misdemeanor warrant, and Melvindale has indicated that they would not pick up on that warrant.
Well, I'm just looking, do you want 12 days out or you want 1 week? Because she's in custody. So I can do the 1st or the sixth?
Fortunately, Judge, I'm in trial next Thursday, so I can't do next.
Can't do the first, so I'll set it for the sixth for BCC. It's a Tuesday.
I haven't looked at the 2,000 cash security bond on an RIO A and B case.
I thought you had you said you had
That's what he said. No, there's not.
After failure to appear.
All right, I'm just trying to give her the quickest date I can.
Understood, Judge.
So if you're not available the first, I'll do the sixth.
That would be great, Judge. Thank you.
May sixth, 2025. That's at 9 a.m. All right, for a probable question. All right.
Thank you, Judge.
Thank you.
Would also like to address bond. I know we've
She would.
touched on it a bit. It's my understanding her bond in this matter is 5,000 with a 10% bond. It's my understanding of the circuit court matter that I think the people were mentioning a second ago. My client tells me she received a personal bond on that file at her last court date. She is 34 years old. She does have employment lined up should she be released. She would be working at a medicinal cannabis retail store. She would.
Okay.
She does.
Like she has a job at a liquor store. Go ahead. No, I'm kidding.
Very, very important jobs. It's a very important sector of our economy. She does have housing lined up as well.
Wow.
She would be
vouching for that.
She would be able to reside in the city of Ypsilanti with a friend. She also is on the housing list through Avalon Housing. She would be working with CMH. She, previous to her incarceration, was working with CMH and attended therapy at least 2 times a month. It's my understanding that the other holds out of Wayne, as mentioned, they would not pick up on. We did ask the court to consider a personal bond. If the court is unwilling to do so, we would also ask if the court would consider release to treatment. She has indicated that she does think treatment would be appropriate for her at this time.
Kind of treatment.
Substance abuse treatment.
Ah, at the cannabis store. No, I'm kidding. Go ahead.
Your Honor, at this time, we believe that her bond is appropriate. She does have multiple other matters pending. We would point out that the date of offense in this case is the day after she was released on another case. I don't know if you remember Ms. Gregg from last time she was here. But Your Honor, given that she picked up this case.
Because she had to get away from here after she was released. So she just grabbed a car. Whose car did she grab? Allegedly.
Allegedly, Judge.
Allegedly, it was a police car.
No, what?
Okay, never mind. My bad.
No.
She just took a car because she had to go. Allegedly.
Allegedly, Judge.
And she's already had a failure to appear on the RNO case back in February. So we don't think that a reduction in bonds.
If I may, Judge.
Go ahead.
Judge, my only response to that would be treatment, I think would be perhaps a great middle ground for her. She's indicated a willingness and a desire to obtain treatment. Certainly, I think with treatment the risk of failure to appear is significantly diminished.
You prepare an order, I'll release her on a PR to treat.
Thank you very much, Judge.
Your Honor, could there be a tether to keep her in inpatient treatment at that place?
I don't know if she's gonna need a tether. I mean, if she goes into treatment. No, I'm not gonna do a tether on her. I'll just indicate that she can be released from treatment on a PR.
Thank you, Judge.
At this point, however, her bond will continue.
Thank you.
Court does call the case of the People versus Muhammad Farr.
Good judge.
Andrew Childers, appearing on behalf of the people.
Tor Shofis, First Assistant Public Defender on behalf of Mr. Muhammad Farha. Please state your name for the record, sir.
Muhammad Farha.
Thank you, Judge. We are still in the process of trying to get this matter resolved. We are requesting a brief adjournment so he can provide proof of his treatment to the prosecutor's office, and we can hopefully find a resolution, Your Honor. He is in compliance, as far as I can tell now. Last time we were here, you had him go drop and he dropped and came back clean, Your Honor.
I have proof of treatment with me right now.
Okay, well, he's gonna need time to review it.
Okay.
So you're looking for how much time?
Just a couple weeks, Judge.
Probable cause conference in this case will be adjourned May 6, 2025, 9 a.m.
Thank you, Judge. I'll provide that proof to Mr. Childers and try to get this matter resolved on that time.
All right. Thank you, Mr. Clark.
Yes, everything is still in place.
Okay.
Keep doing it. Thank you, Judge.
Court calls the case People versus Antonio Jackson.
Alice, on behalf of the people, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Jackson. Will you say your name for the record?
Antonio Jackson Jr. Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
Your Honor, if I could address bond appropriate.
All right. Discovery is complete.
To our knowledge, yes, Judge.
People have their witnesses available to set.
We'll do our best.
She's up.
Set preliminary examination in person, May 6, 2025,
9 a.m. before the hearing.
9 a.m. before Judge Perry. Yes, Esteban.
Your Honor, I do want to make the court aware, in checking the defendant's jail calls, he has tried to contact the victim 33 times since arraignment. She's not picked up the phone, but he has been trying to call her 30 times.
Any response?
No, Judge.
Defendant's phone privileges at this time are revoked. Found otherwise, we'll continue. Thank you. Yes, to the extent it's true. After the second time, why are you calling back? Never mind. Court calls the case People versus Durantu Francis. That's
Special lines of people.
Good morning, Your Honor. Assistant Public Defender Tanazi Carey accurately on behalf of Mr. Durantu Francis. Ms. Francis, state your name for the record, please.
To Francis.
Thank you.
The court should have a green sheet.
I do.
I think we did receive an offer today. We just need to relay it to Ms. Francis, and I think 2 weeks should be fine, Judge.
Probable cause conference, May 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Continue. All right. Thank you, ma'am. Case People versus Sean Johnson.
And is it on behalf of the people, Your Honor?
Mike Daddy, Assistant Public Defender, Mr. Johnson. He's in lockup too. He's making his way to the.
What? Sorry. You're there. Johnson.
Your Honor,
state your name, sir.
Sean Michael Johnson.
Thank you. What are we doing?
Your Honor, we're asking you to set this for a preliminary exam.
Discovery is complete.
Your Honor, I have spoken with Ms. Zenda. There was some video. She says it's on our way to our office, so I'm confident.
And that's correct, right? There's a meeting, so it should be here by Monday. And if people could address bond appropriate.
Preliminary examination in person will be set May 6, 2025. Huh?
Yeah.
It's at 12 noon before me. Esteban.
Your Honor, this defendant has tried to contact the victim 29 times since arraignment with one completed call. And in this call, he talks to their child, who then passes the phone to the victim. And in that call, he asks the victim for money to put on his account and also tells her, you know, I'm going to prison, right? So I'm concerned that's his phone privileges be revoked. We'll be asking the jail to block that number.
Your Honor, I was made aware of this earlier this morning. I haven't had a chance to look into it. I guess I'd ask the court as an interim provision to block that number, the alleged, the number of the alleged contacts and not revoke the privileges. I believe the bond is currently set at 25,000, if I'm not mistaken.
If bond will continue, defendants' phone privileges are revoked. You can raise it if you find out something different at the time of his preliminary examination, but at this time they're revoked.
Thank you.
Court does call the case, People versus Lena Harbali.
People.
Your Honest.
Okay.
Mike Gaddy, Assistant Public Defender for Ms. Harbali, who's here to my right. State your name, ma'am.
Lena Harbali.
Thank you.
Thank you. Your Honor, we are requesting an adjournment for this matter. We actually did submit a Zoom request, but Ms. Harbali was released from the hospital in time to be here today. So we are endeavoring to go to mental health treatment court. I have reached out to Mr. Graveline. I haven't heard back. Oh.
No, go ahead.
Whenever someone does something, I always think it's me.
No.
We are trying to get screened for mental health court. There was a delay based on.
Okay, no, that's fine. Probable cause conference, May 22nd, 2025, 9 a.m. All right, bond will continue.
Thank you, Judge. It's right on file.
Your Honor.
Thank you. Court calls the case, People versus Anderson Keller.
Good morning, Assistant Public Defender Davi Lebo, on behalf of Mr. Keller, who's approaching from my right. Mr. Keller, could you please state your name, sir?
Anderson Christopher Keller.
Okay, what are we doing?
Your Honor, we're here today for a competency hearing as well as a probable cause conference. I have received the competency report from the Center for Forensic Psychiatry and would be prepared to stipulate the results finding Mr. Keller competent.
Are you talking about the March 13th report?
Your Honor, I can double check the date on it, but I believe so. Actually, yes.
Are the people in receipt of that report?
Yes, Your Honor.
All right.
We would also stipulate we have no further reference.
Based upon that report, the court would find that the defendant is competent.
Your Honor, with regard to the
report specifically would indicate that the defendant can understand the nature and object against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. Do you have an order?
No, Your Honor, I can prepare one.
Okay. All right, what are we doing?
Your Honor, with regard to the PCC, would like to set this matter for preliminary examination, please.
You have all the discovery?
Yes, Your Honor.
We'll be able to have their witnesses available to 6.
I don't know, Your Honor. I'll try for that date.
All right. Preliminary examination will be set May 6, 2025, 9 a.m. before Judge Perry.
Thank you, Your Honor.
Court calls case People versus Brian Howell.
Ashley Money for the people.
Your Honor, Constable Base on behalf of Mr. Brian Howell, who is present to my right. Mr. Howell, can you state your full name for the record, please?
Good morning, I'm Brian Howell.
I had before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that he's going to plead to use of a controlled substance to 1-year misdemeanor. Upon a successful guilty plea to that charge, count 1 would be dismissed. Well, hold on a second. He's also going to plead to counts 2 and 3 as charged.
That's correct, Your Honor.
So he's pleading to counts 2, 3, and 4.
Yes, Your Honor.
Correct, Your Honor.
And then, okay, and then count 1 is dismissed. Is that That's the court's full understanding.
Yes, that's correct, Your Honor. And my client is looking to get into the drug treatment court over in Oakland County. He has spoken with them over there. But it's pending this plea so that we have to get this done.
So with this plea, he'll be able to get in?
Correct.
All right. I know we've been trying to do that a minute. May I have him sworn?
Right. Do you solemnly swear and affirm the testimony you're about to give? Do you solemnly swear and affirm the testimony you're about to give with the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
State your name.
Brian Howell.
All right. Sir, it is this court's understanding that you're going to plead guilty to 3 misdemeanors. Is that correct?
Yes, Your Honor.
All right. First of all, that you're going to plead guilty to the stated count 2 of operating with your license suspended, denied, and or revoked. That's a misdemeanor punishable by up to 93 days, $500 fine plus court cost. Vehicle could be subject to mobilization. Understand that?
Yes, Your Honor.
Count 3 also that you're going to be pleading guilty to is the charge of open intoxicants in a motor vehicle. That's a misdemeanor punishable by up to 90 days, $100 fine plus court cost, community service, and any substance abuse treatment. You understand that?
Yes, Your Honor.
And then also that you'd be pleading to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. You understand all of that?
Yes, Your Honor.
All right. And you understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Yes, Your Honor.
Understanding that you still wish to plead guilty to these charges?
Yes, Your
Honor. To the charge of driving while license suspended, denied, and or revoked, how do you plead?
Guilty.
To the charge of open intoxicants in a motor vehicle, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form?
Yes, Your Honor, it's here.
You signed an advice of rights form?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
Were you on probation or parole at this time of these offenses?
Yes, Your Honor.
All right. Then I need you to understand your plea in this case could be a violation of that probation. And you need to understand that as such, that other court could sentence you to the maximum allowable under those other charges. You understand that?
Yes, Your Honor.
And understanding that, you still wish to plead guilty to these charges?
Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and because you believe that you're guilty of these offenses?
Yes, Your Honor.
March 17, 2024, at the location of M52 near Newkirk Road, Manchester Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes, Your Honor.
At the time, was your driver's license suspended, denied, and or revoked?
Yes, Your Honor.
And did you know that it was?
Yes, Your Honor.
All right. And while you were operating that motor vehicle, did you have open intoxicants in the motor vehicle?
Yes, Your Honor.
What'd you have?
I had an open tall boy, which is open beer.
Really? Like I didn't know, because I just crawled from under a rock. I get you. You had an open beer in the vehicle, right?
Yes, Your Honor.
Okay. And you knew it was there?
Yes, Your Honor.
All right. And it was yours?
Yes, Your Honor.
All right. And had you used a controlled substance on that day?
Yes, Your Honor.
What?
Adderall.
All right. Did you have a prescription for it?
No, Your Honor.
All right. And you knew what you were using was Adderall?
Yes, Your Honor.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is also satisfied, Your Honor. Thank you.
Court will accept the defendant's pleas of guilty to counts 2, 3, and 4. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing will be June 10th, 2025, 9 a.m. before Judge Freshour. And on this will continue. Mr. Howell, good luck to you, sir.
Thank you, Your Honor. It's been a pleasure.
Thank you. Court does call the case of People versus Michael McLean.
And then we have the people, Your Honor.
basically on behalf of Mr. Michael McLean, who is present to my right. You state your full name for the record, Michael?
Michael James McLean.
Thank you.
Today is the date and time set for probable cause conference. At this time, we'd be respectfully requesting to set this for a final settle. I'm sorry, not final settlement, preliminary exam.
And your people can just bond.
Yeah, of course. Hang on. Would people have their witnesses available on the 6th? Preliminary examination in person, May 6th, 2025. 9 a.m. Is it 12? 12 noon. That's before me. Yes, I should bond.
Next come to my attention, he has made 127 attempted calls to the victim since arraignment was 2 completed on 4/16 and 4/8.
How many?
127 attempted calls, 2 were completed. So I'd be asking that his phone privilege would be revoked.
Oh. Honest?
No comment at this time, Your Honor.
His bond will continue. His phone privileges are hereby ordered revoked.
Thank you, Your Honor.
I was married 15 years. It's all set. How's the case, people versus Zakaria Haruska Dennis.
Rachel McDuffie for the people.
What?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Haruska Dennis.
No, wrong. Doesn't matter, he's not here.
Just for the record, I'd ask for an adjournment. He did reach out earlier this week and left a voicemail. I attempted to reach out and follow back up. We are missing some outstanding discovery, but I don't have an answer for his non-appearance today.
Bench warrant will issue. Bond 10,000. Cash surety, that warrant will issue immediately for Mr. No. I'm telling you. Court calls the case people versus Robert Mitchell.
For the chair with and on behalf of Robert Mitchell.
Robert Mitchell.
Thank you, sir.
To our knowledge, discovery is complete and we request the earliest possible exam date that the people can accommodate.
People have their witnesses available to 6.
We'll try, Your Honor.
Preliminary examination in person, May 6, 2025, 9 a.m. Is it 9?
Yes.
Before Judge Perry.
Thank you, Your Honor.
Thank you, Bond.
Thank you.
Thank you. Court calls the case people versus Anthony Johnson.
Alexander, on behalf of the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Johnson, who appears to my right. Mr. Johnson, can you state your name for record? Anthony James. Your Honor, we submitted a waiver request on this.
All right. So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that you won't have that proceeding and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 following.
Acknowledge receipt of information, Your Honor. Wait formal reading, stand mute at this time.
Defendant have a waive formal reading, standing mute to all counts. Court will enter a not guilty plea. Pre-trial will be set for
June 17th, 1:30 before Judge Cedric.
June 17, 2025, 1:30 Judge Cedric.
And Your Honor, we can address bond briefly.
Okay.
It has come to my attention from the victim, she sent us a screenshot that the defendant has sent her a Facebook request, friend request. So that concerns he's trying to reach out and contact her.
Your Honor, in talking to my client, we have decided to address this issue head on. My client has an explanation for this that he would like to offer to the court.
Go ahead. Is he admitting to that? Is it Mr. Allen?
He is admitting to that, Your Honor. The explanation is. Go ahead. You want me to?
I can say it.
Okay.
It was a mistake. I was pushing remove and push add frame. That was simple. That's what I did.
Your Honor, he tried to eliminate the possibility of any contact. He saw that she popped up. He wanted to remove any possibility that he could have contact with her. That was his intentions. And
how did that even happen though?
Just,
okay.
Big thumbs, Your Honor.
I was a mistake, sir. I admit it though.
He didn't intend to contact her. There's no allegation that he actually made contact with her. Like I said, he wanted to eliminate the possibility of that. He made a mistake.
In reporting the violation to us, I believe she told us that she had made an entirely new Facebook account, not using her name, and that was the account that sent a friend request to. She wasn't sure how he found that account, but he added her as a friend and she needed to report it.
Your Honor, the only thing I can provide is that when new accounts pop up, the suggested friends that pop up, he likely noticed that it was probably hers. He intended to remove it to eliminate any possibility of contact. He immediately, when he clicked add, he immediately went back and clicked remove. Realizing the mistake, he blocked her. Again, there's no allegation that he actually had contact with her. He doesn't want contact with her. He understands that he's on bond and he doesn't want to do anything to lose that. And
do not have or attempt to have direct or indirect contact with the above individual in person or through others by electronic communication, including but not limited to phone, email, texting, internet, or social media.
Well, Your Honor, if it was not under her name, I don't know how he could possibly have also known that it was her definitively.
Then why would he have attempted to remove it?
Because the possibility that it could have been, I imagine. He advises that it was her face. So he wanted to.
He knew.
Well, Your Honor, he is just providing an explanation as to why he wanted to eliminate the possibility of contact. It did pop up. He did remove it. He's asking that the court. He blocked her. He is asking that the court take that into consideration. He's asking, we are pleading with the court to allow him to remain out on bond at this time. And he was, for what it's worth, honest with the court about that. He is taking accountability for it.
Anything else? Tell you not to have contact. He sees her face. He attempts to make contact with her. He can't violate the bond that way. Just plain and simple. Defendant's bonds revoked. Defendant's remain. Court case, People versus Bruce Pickens.
Stephanie Can on behalf of Mr. Pickens, who is appearing to my right. Mr. Pickens, could you please state your name for the record?
Bruce Pickens.
Your Honor, you should have a green sheet in your possession. I'm simply asking for a 2-week adjournment. An AIM request has been done for my client to see if we can get some mitigation.
Said 2 weeks?
Yes, sir.
I need 12 days, so I'll set probable cause conference in these matters will be May 6, 2025, 9 a.m.
Also see you before then, and you'll hear from our staff to try and get you some mental health and also start working on a home.
Bond will continue. Thank you.
Thank you.
Case, People versus Marcus Jones.
Judge.
Hey, how you doing? I'm doing.
Marshall Feast, the first assistant public defender on behalf of Mr. Marcus Jones. Mr. Jones, please state your name for the record.
Marcus Jones. Thank you, sir.
Andrew Jones, People.
Thank you, Judge. I think we were here a couple weeks ago, which time Mr. Jones was in treatment. He is now out of inpatient treatment, out of the hospital, but he's going to be going back into a outpatient.
Patient
Yes.
program.
So, my understanding is, once he completes that, that might have an impact on the resolution in this case. So I'd ask for, 3 or 4 weeks or more adjournment so we can get him going.
If I may, Your Honor, I did attempt to do, I'm sorry, I did set an appointment for myself, but I missed it, so I had to reschedule another appointment. So I was planning on scheduling another appointment, after court today.
Today, okay, all right, real good. Let's do this then. Let's see how you're doing through the program and everything. I'll adjourn it out to May 29th.
Okay.
Okay. Thank you.
Okay, you're welcome. 2025, 9 a.m. Okay, you take care of yourself, young man.
Got something ready.
Yeah, I'm making a hallway. Okay. Thank you, Judge.
Court calls the case, People versus Scott Reese.
That's a lot of people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Reese. Please state your name for the record.
Scott Reese.
I think we're going to be filing an only cross in this case.
Any objection?
No objection.
Case is dismissed.
Missed all three counts.
Okay, thank you.
You're welcome.
Thank you, sir. And then why were you like giving him the fist like you did something? You didn't do you did nothing. You did nothing. You did nothing. That was Miss Apple's victory. You just, you know what? Just don't even try.
That's awful one, Your Honor.
Court calls case, People versus Maurice Kihei. Or Kihei.
And then now we have the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Kihei. Mr. Kihei, can please state your name for the record? That's how you pronounce it, right?
Yeah.
Okay.
Maurice Kihei.
Kihei.
Your Honor, can you briefly approach?
Oh, boy. Bellinger, really? It's like every week. This is a prop.
Every week?
Yeah.
When's the last time I was at this bench?
Last week. Yeah. It was. GPS location. Okay. All right. Record to, like we had a brief lunch conference. You want to just put out a couple weeks.
We are asking for a couple week adjournment, Your Honor.
All right. I'll adjourn probable cause conference to May 15th, 2025, 9 a.m. I would indicate also that in reviewing the bond, and given some concerns, that defendant is to be placed on a GPS tether with a hot zone for the victim's address. Victim's address.
Okay.
Otherwise, his bond will continue. All right. So, sir, need you before you leave the facility here to go over to community corrections to.
Yes, sir.
That all right?
That's time?
No.
Right across the street.
Okay.
Okay.
Thank you.
When you leave here, it's gonna be the first build.
Okay.
Okay. Thank you, Your Honor.
All right. Thank you. All right. Court does call the case, People versus Alan Reinhackle.
Thank you, Your Honor. Call Bill Basie on behalf of Mr. Alan Reinhackle, who is approaching to my right. Mr. Reinhackle, can you state your full name for the record, please?
Alan Gordon Reinhackle.
Thank you.
Thank you, Your Honor. Today is the date and time set for a probable cause conference. At this time, we'd be requesting to set for the earliest date of preliminary exam.
All discovery is complete.
To my knowledge.
People have their witnesses available to 6. Preliminary examination in person, May 6, 2025 at 12 noon. That's before me. Thank you. Court calls case of the People versus Brianna Kingsley.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Jay Bellinger on behalf of Ms. Kingsley, who appears via Zoom, Your Honor.
Yes. Kingsley, can you state your name? I'm frozen up here. Nice picture of me, but I'm frozen.
Looking good.
Brianna
Oh,
Kingsley.
hold on, Ms. Kingsley. We got to get the video set in the courtroom. What? My iPad?
Yeah.
My iPad's operating fine. Ms. Kingsley, can you say something?
Brianna Kingsley, hello.
Okay, yeah, she's, okay. I just need you to come to my screen, okay, but we're good.
Everything looks good.
Thank you. What?
Just turned your video off.
Something happened, okay. All right. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor. It's going to be a no contest plea.
All right. I have a no contest plea to attempted unlawful use of a motor vehicle, the 1 year offense, that being the count 2. And that count 1 would be dismissed. That's the court's full understanding of the agreement.
That's my understanding as well, Your Honor.
All right. Okay. Ms. Kingsley, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, state your name again for the record.
Brianna Kingsley.
All right, Ms. Kingsley, it's this court's understanding that you're going to plead no contest to the charge of attempted unlawful use of a motor vehicle. That's a misdemeanor punishable by up to 1 year incarceration, a $750 fine plus court costs. You understand that?
Yes,
Also, I have, well, do you understand what a no contest plea is? Let me ask you that.
I'm not contesting the charges, but it's treated as a guilty.
Well, okay, you can look at it that way. 2 things I need you to understand about it, and that is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes,
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
yes,
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
yes,
All right. Understanding all of that, do you still wish to plead no contest?
yes,
Basis for the no contest plea?
Fear of potential civil liability, Your Honor.
All right. So to that charge, how do you plead, Ms. Kingsley?
no contest.
You understand that by pleading no contest, you will not have a trial of any kind?
Yes,
All right. You signed an advice of rights form or gave authority to sign the advice of rights form to counsel?
yes, I gave authority.
All right. Do you have any questions regarding any of those rights?
No,
All right. Paragraph 5 are your rights which are part of a trial. You understand that you're giving up those rights specifically,
yes,
as well as all the rights that are contained on that form. You understand that?
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
I am, but I was not at the time of the offense.
Thank you. All right. Has anybody promised you anything other than what's been stated here today to get you to plead no contest to this charge?
So there was, no, not for this case.
She said no, not in this.
Not in this case. All right. Has anybody threatened you or coerced you in any way to get you to plead no contest?
No,
You're doing this voluntarily
yes,
and of your own free will.
yes,
Has been handed and has reviewed University of Michigan Public Safety and Security Department report for their case number 2490304894. Any objection to the court having reviewed that report?
No, Your Honor.
Okay.
On a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this case will be
May 23rd, 8:30 for Judge Perry.
May 23rd, 2025, 8:30?
Yes.
8:30 before Judge Perry. Bond in this case will continue.
Thank you, Your Honor.
Thank you. Take care, Ms. Kinsley.
Thank you, you too.
Court does call the case of the people versus Jason Burkett. Or Burkett.
And good afternoon or good morning, Judge. I'm Amir Mclofflin on behalf of Mr. Burkett.
Good afternoon. Morning. Good afternoon. What's your name?
Jason Matthew Burkett.
All right. Okay, what are we doing on this case?
Your Honor, I'm asking to be withdraw as counsel for Mr. Burkett. I haven't spoken to him. He was capious last time we were there, and we were never retained. So I'd ask the court to allow me to.
You were never retained. Say again.
He was supposed to retain us, or a family member, or his employer was supposed to retain us, but nobody ever did.
Wow. Okay.
And the last time we were in court, he capious, so I haven't had any contact with him since then.
Okay, so, well, we got a problem then. Constantino's not still here, is she? Oh, is she coming back?
She was in the hall.
She was in the hall?
She was in this room.
All right, so we may be able to, because the PD initially withdrew on his case. Part of that withdrawal appointed Constantino, but then I think you were going to step in. So that's kind of what. Well, no, hold on.
I had it, Your Honor, as the PD got out because Mr. Mclofflin got hired, but I'm not sure that could be incorrect.
No, no, because I have the withdrawal, the motion to withdraw that I signed, the order of withdrawal, and then Ms. Constantino was appointed to represent you.
She's not here.
She's not here. All right. So sir, do you have any objection to Mr. Mclofflin withdrawing?
I have no idea what's going on, sir. I thought, no, if he's withdrawing, then I don't.
Okay, so here's what I'm gonna do. I don't think I need a new order, but what I'm gonna indicate is that
I don't know how things got confused, Your Honor. I'm sorry.
I'm gonna permit him to withdraw.
Thank you, Your Honor.
And then I'm gonna indicate that the PD previously withdrew.
Due to a conflict, Your Honor.
I know. Why are you slipping in? Why are you slipping? Sit down. Well, I'm gonna need it. Yes, I'm gonna need an order from you, counsel, permitting withdrawal. The court isn't appointing, but the court, I'm gonna have this case go back to Ms. Constantino. And we'll do it that way.
I'll email the court within a few minutes.
Alrighty, thank you, sir. Sure. All right, and here's what I'm gonna do. She's coming back. You're next week. He wasn't available on the 1st. So here's what I'm gonna do, sir. I'm gonna set the next available date so that counsel can get to you talk to you and see what we can do.
Is there anything, I wanted to ask, is there any way I could be released on the PR bond? Like I said, this got confused. I thought he said we were getting dismissed and we got crossed up. I would have never missed. I talked to Officer Stanky actually on
All right,
Friday.
let me do this. Hold on.
Okay. 'Cause I'm
Probable
looking at
cause
the job tomorrow.
conference, May 6th, 2025, 9 a.m. Do people have a position on his bond?
Just one moment here, just to get a warrant request.
And can I say one more thing? I'm sorry, sir. I was trying to get in with the,
So, sir, why didn't you show up the last time?
the last time, like you said, we were confused. I thought he said he was gonna call me back and tell me a court date. I never received a court date. I would have reported. And like I said, I spoke.
How'd you come back into custody?
Well, I talked to Officer Stinky on Friday and he told me he said it was a forgery charge I had out for me. I see him down by the Delana Center and then Delana said that I was threatening to commit suicide. So they called the police on me and then they ended up picking me up that way. But, kind of still have like an interview I could get tomorrow. I was wondering if I could, any way I can make it out to make that. I really need this job.
I'll leave it in the court's discretion. I see one hold in your warnings for traffic, for driving suspended, so I don't know if we can get him on that or not. I really
Doubt it.
know. But, I don't see a big history of tires with the at one time.
Yes, like I said, it was a complete mix up.
I'm gonna set your bond at a $5,000 personal recognizance. All the conditions that we previously set will apply.
Okay, thank you very much.
Setting your new date for May 6, 2025 at 9 a.m. here.
Well, sir.
If you don't show up, you won't see the light of day.
I'll probably be early.
You hear me?
I'll be early, sir. I appreciate
Thank you.
that. Thank you.
And Ms. Constantino will be getting in touch with you.
Thank you.
Court does call the case people versus.
I'm sorry, my phone was broken on Sunday. Is there any way I can get like a business card for her? So I can call her tomorrow? I mean, I might have a new phone tomorrow. I just wanted to make sure.
Judge, I have her number. I can write it down.
Thank you.
Pass it to the guard.
Thank you, Mr. Getty. As I watched everybody just stare off like sheep pot. Yeah, so Ekenruli, when that happened, you couldn't stand up and like interject, could you? Huh? You said absolutely nothing. Court calls the case people versus Eric Coons.
Stephanie Can on behalf of Mr. Coles, who is
Oh,
appearing to my
you're
right.
actually gonna do something today besides take credit for Miss Apple's victories.
Be honor, it's all for one here, all for one.
Yeah,
Please
they
state your
don't
name.
think that way when you, what you do. All right, I'm just saying. Your name, sir? Eric Coon. Thank you.
Your Honor, I do believe you should have a green sheet for Mr.
I
Coles.
do.
We're just asking for a 2-week adjournment in this matter. There's normally having sheets, so sorry.
May 15th. Adjourn out a little bit longer than that, okay?
Okay.
Preliminary or probable cause conference, May 15th, 2025, 9 a.m.
No problem.
All right. Bond will continue, sir. Thank you.
Thank you so much, Your Honor.
Court calls case people versus James Richmond.
Alexander, on behalf of the people.
Hannah Apple appearing on behalf of Mr. Richmond. No. Mr. Richmond, will you state your name for the record?
My name is James Richmond.
Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
You have all discovery.
Yes, Judge.
People have their witnesses available the 6th.
Yeah.
Preliminary examination in person, May 6th, 2025, 9 a.m. That before Judge Perry. Bond will continue. Thank you. Court does call the case of people versus Sanders. Quinard.
Public defender on behalf of Mr. Sanders, Your Honor. State your name, Mr. Sanders.
Quinton Sanders, thank you.
Your Honor, we're gonna ask the court to set this matter for an exam.
Discovery is complete.
Yes, Judge, as far as I know.
People have their witnesses available the sixth. Preliminary examination in person, May sixth, 2025. 12 noon. That's before me.
If I can be heard on bond, Judge.
Sure.
Your Honor, Mr. Sanders is here. He's, he has an exam schedule, obviously. He is, a local resident. He's not a flight risk, in any way. He has missed some court. It was, some of it was due to a medical, situation that is ongoing here in the jail. He, reports that he hasn't been able to get the, kind of care he was, getting on, when he was outside. He has a issue with his lungs. There's certain medications that he does take that are not available to him here. Now.
What do you mean they're not available?
Well, the jail has not made them available. I don't know if they're prohibited from being in the jail or if they just haven't gotten them yet or are able to get them. He's missed medical appointments. He has, I've instructed him to kite those, to kite this. I don't know if he's received any responses. Also, I'm not going to gild the lily. He does have a MDOC hold. I have reached out to his parole officer. She was not the most forthcoming about what would happen. It's my understanding they have 4 days after he's not being held here to submit a report, and then it goes to the supervisor there who makes a decision as to what they are going to do. But I don't have any knowledge as to that. I've reached out to the supervisor as well and have not. I talked to him yesterday, but he didn't have any information for me. But he is local. He's not a flight risk. He has a place to stay.
I don't need a response. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
And then you seem to take credit there. It's ready. You got Ronald Sims? Got him. Court does call the case, people versus Ronald Sims.
Assistant Public Defender Davy Lebo on behalf of Mr. Sims, who stands to my right. Mr. Sims, can you state your name, sir?
Ronald Sims.
Thank you.
And Your Honor, we'd like to set this matter for preliminary examination, please. We do have complete discovery.
No other witnesses available to six. Preliminary examination in person, May 6th, 2025, 9 a.m. Is that right?
Yes.
9 a.m. before Judge Cedric.
Thank you, Your Honor.
Bond continued. Thank you. Court recalls the case, people versus Brendan Chrysler.
People.
James Slatfelski on behalf of Mr. Chrysler. Fortunately, he has not been able to get here. I did talk to him on the phone a couple of times. He's stuck in Flint and he has not been able to get transportation. So I'm asking for a 1-week adjournment. And that's all I have to say.
Your Honor, has the court received the community corrections report?
Yes.
He's missed his last 2 tests. People are requesting bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in amount of $25,000 cash surety. That warrant will issue immediately. Thank you.
Thank you, Your Honor. Have a good day.
Court calls case, people versus Dominique White.
And then on behalf of people.
Second again on behalf of Mr. White. Mr. Whitman, your presentation into the record.
Dominique White, Your Honor.
Your Honor, we're just simply asking for a preliminary exam in this matter at court's earliest convenience.
You have all discovery?
Your Honor, I do believe that we have everything.
People have their witnesses available to 6. Preliminary examination in person, May 6, 2025. 12 noon before me.
Thank you, Your Honor.
Thank you. Court calls the case People versus Danielle Lamadin. Admitted.
Carolyn Foster Tucker on behalf of Danielle Laneman.
That's what I said. Okay.
Your Honor, I was informed this morning that she is in the hospital and is not here today. I would just request a 2-week adjournment.
Without objection, I'll grant the adjournment in this case. She'll be adjourned to. Sure. Make it May 15, 2025. 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. That's everything? We come back at 12:30? Wow. Almost have an hour. Yeah, after everything's done, then Brown shows up. Court's gonna stand in recess.
I'm sorry, Your Honor, may we approach briefly before you go on?
Yeah, he's gonna have to clear that aisle because they're bringing somebody out. Court does recalls the case of the People State of Michigan versus Quinton Sanders.
Anderson is here on behalf of the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Sanders, who's here to my right. State your name, Mr. Sanders.
Quinton Sanders.
Your Honor, thank you for calling this case. I wanted to clarify something that when arguing bond, I had said Mr. Sanders had not appeared in court because of his not being well. I'd like to point out he was in the hospital. And in fact, I think the February PCC was adjourned based on that. I do have a letter to that effect. He was a victim of a stabbing, and then later his lung collapsed and he went back to St. Joe's. I don't have any clarification as to that right now, but we can certainly endeavor to get it if the court would like to see it. But he does report that he did contact our office about that. In terms of the medication he's not able to get, it's a pain patch, which kind of makes sense, which explains it. And again, I have contacted parole about this matter a couple times, and I was able to speak to the supervisor once, who instructed me to call him back again at 8 in the morning, and I did, and it didn't work out. But it's Mr. Sanders' understanding that if he is released, he will get put on a tether by MDOC and reinstated on parole, with his discharge date being backed out to February 26th. But I'm not able to verify that. But that's his understanding as well, and
that's his understanding, but they haven't verified that's what they're intending.
I have not been able to verify that. He reports that his family member, his mother, has spoken to the parole supervisor, Chase Dozell. I believe is how you pronounce his name, and that's his understanding. And he does have a place to reside, Your Honor, which is here in town on Gulf Side. I just want to make sure the court had all that information.
Yeah, some of that is a bit different than court procession, but overall, it would not change the court's view of whether or not to reinstate the defendant's bond or to do something different. I appreciate the clarification. It's the court's decision that the defendant's bond will remain the same so that the motion is denied.
Your Honor, one thing came to my attention. Since we passed the matter, I had sent an email to the Ypsilanti police officer who's involved in this case. Has already responded that he is out of town on vacation. That we set this exam, we set it for May 6th.
Yes.
I don't know if the court would entertain right now my request to bump that 1 week in light of that information, but it doesn't appear that we will be able to proceed to an exam on May 6th due to his own availability. And this is a single witness exam.
Well, he's got the parole hold anyway, so I'm gonna put it to May 13th.
Your Honor,
1 week out over the objection of.
Yeah,
13th at 9, that still would be before me.
and we would object to the move, Your Honor, but in terms of his bond or his exam dates moving out, if we are able to ascertain some more or obtain some more information from St. Joe's about his hospitalization, I'd ask the court to consider a motion to.
Yeah, I mean, and it could be done one of two ways. You can either send the information to me for my consideration, or if you contact my office and would like it scheduled when on a PCC day. So for me, that's going to be the 1st to 6th prior to this 13th date. Certainly, I would entertain hearing it depending on what the docket looks like.
Thank you, Your Honor.
Thank you. Court calls case People versus David Lee Sherman. Madam Attorney General, if you could take your appearance, please.
Yes, good afternoon. Assistant Attorney General Clarissa Williams on behalf of the people.
Good afternoon, Your Honor. Edward Drukas on behalf of David Furman.
Mr. Furman, can you state your name, please?
David Lee Furman.
Thank you. He shut off his camera, but I saw him. All right, what are we doing?
Your Honor, there might be a nollie press in the file.
Is there? He did tell me that there was, okay. So this case is being dismissed. All right, case is dismissed. That's by Nally Pross. Court has signed that. Thank you, folks.
Thank you, Your Honor.
Thank you,
Your
Mr.
Honor.
Furman.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Jacob Jackson. It's also an Attorney General case.
Good afternoon, Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Jackson. Mr. Jackson, could you unmute yourself and state your name for the court?
Jacob Jackson.
All right, what are we doing?
Your Honor, Mr. Jackson and I discussed waiving his preliminary examination. Unfortunately, because he's on Zoom, I don't have a signed waiver. I'm wondering if the court
Is he gonna waive? He wants to waive?
Yes, Your Honor.
Mr. Jackson, is that correct? You want to waive your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Ms. Yagi.
We would waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
June 17th at 1:30 PM.
Judge who? June 17, 2025, 1:30, Judge Conkey. Bond continued. Thank you.
Thank you.
And I think I have one more for you, Madam AG. Court does call the case of the People versus Joseph Wynn.
And Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Wynn. Mr. Wynn, can you state your name for the court?
Joseph Wynn.
Yes, Ms. Yagi.
Your Honor, I am asking for an adjournment in this matter. Mr. Wynn and I have been in communication, but we are asking for a little bit more time for me to look into a couple things and for him to get set up online with the payments.
All right. That objection, I'll adjourn probable cause May 15th, 2025, 9 a.m. or as your invite indicates. Bond will continue. All right, thank you.
Thank you, Your Honor.
Thank you.
All right, thank you. I think that's it. Madam Attorney General. Court does call the case, People versus Armani Taylor.
Good afternoon, Your Honor. Sydney Rushing appearing on behalf of Ms. Taylor. Ms. Taylor, can you please state your name for the record? Armani Taylor. Thank you.
All right, what are we doing?
Your Honor, we're asking for a brief adjournment so that way we can receive discovery.
Say that again. I don't know what's happening with my speaker.
Your Honor, we're seeking an adjournment so that way we can receive discovery and review it.
Probable cause conference, May 15th, 2025, 9 a.m. Or as your invite indicates, bond continued.
Thank you so much, Judge. Have a great day.
Thank you. You too. Court does call the case of the People versus Harold Martin. Ms. Plumai.
Your Honor, Alexis Plumai appearing on behalf of Mr. Martin. And there's no Mr. Martin in the courtroom. Your Honor, I have not been able to get in touch with Mr. Martin. Unfortunately, I don't have an explanation for his absence. I don't believe he's here today. Harold Martin. So Your Honor, I would.
This be your case?
That's my middle name.
You know, if you want to be your case, let me see what you're charged with. I don't know if you want all this, but well, I don't know.
I would ask for an adjournment. It looks like our office had contact with him just a couple weeks ago. But I haven't been able to reach him this week.
And Your Honor, the defendant doesn't appear over a year ago. The warrant was recalled recently, but it's not here today, so I expect warrant issue.
Bench warrant will issue for defendant's failure to appear, bond 10,000, cash surety. Warrant will issue immediately. Court does call the case, People versus Larry McCullough Hawkins.
Alexander, on behalf of the people.
For Yagi Assistant Defender with and on behalf of Mr. McCall Hawkins, who is approaching. Could you state your name for the court?
Thank you.
In this matter, Your Honor, I do believe we have discovery. There's a 911 call that's en route to our office, so I would respectfully ask that this matter be set for preliminary examination.
911 call.
That's correct. It was uploaded yesterday, so it should be here by Monday.
People have their witnesses available to 6.
We'll try our best.
Preliminary examination in person, May 6, 2025 at 9 a.m. with Judge Perry. Bond continued. Thank you.
All right. Thank you, Your Honor.
Calls case, People versus Charles Meade. Mr. Feaster.
Yes, Assistant Public Defender tonight, I can rule, Your Honor, on behalf of Mr. Charles Meade.
Let me go find her.
At this time, people will be moving to dismiss this case without prejudice, file a knowledge process based on common good and not historical instead.
Any objection?
No objection at all, Your Honor.
Case is dismissed.
Thank you, Judge.
Thank you, Mr. Meade.
You're welcome, Your Honor.
Calls case, People versus Jeffrey Moore.
The people move matters.
Assistant Public Defender Davey Lee on behalf of Jeffrey Moore, stands to my right. Jeffrey Moore.
Thank you. What are we doing?
And Your Honor, we'd like to be setting the 0206 matter for exam and adjourning the 0707 matter to track along with it.
You want me to do what?
Your Honor, I'd like to set the 206 matter for exam and adjourn the 0707 matter to track that other matter.
To track what other matter?
The 0206 matter.
So you want an adjournment on
707, Your Honor.
You've lost me, counsel. I'm just trying to figure out what you want done with these cases. Do you want one of them set for exam?
Yes, Your Honor.
Which one?
206.
Is all discovery on that complete?
It is, Your Honor.
People have their witnesses available to 6.
We'll try, Your Honor.
In this case, preliminary examination will be set for May 6, 2025 at 12 p.m. noon. That's before me. That's in person, bond continued. Now, what do you want done with this other one?
And the other matter, I just want to adjourn to a date approximately around the same date as the exam. As how we're proceeding in that case may depend on how the exam.
It'll be the same date. It's in the morning now.
Thank you, Your Honor.
Probable cause conference, May 6, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Thank you. Court calls case People versus Victor Morris Gerard.
On behalf of Mr. State your name for the record, please.
Victor Morishara.
Your Honor, in regards to the probable cause conference, we're requesting an adjournment. There was still some outstanding discovery that we requested.
You have a green sheet? No.
That's a no. I've got it right here, though.
I don't mind it now, but we do have a problem. Conference 2025. As to the bond violation.
As to the bond violation, and I did have an opportunity to speak with Mr. Gerard. He takes full accountability. He's indicated to me that he has been struggling with depression, and obviously, now knowing that this issue is much bigger than we talked about treatment opportunities. In the report from they did indicate that they have made a referral for CCOP on his behalf as well. He has not spoken with Mr. Brown to see where they are with that program, but I just asked the court to at least give us the opportunity to explore that option and see if we can get him into outpatient treatment.
Well, you might be able to get him into outpatient treatment, but he's clearly in violation because they have had 4 successive tests where he's positive for cocaine, amphetamines, and then his last test positive for cocaine and alcohol, but before the confirmation test on the alcohol, he left the building.
And I did ask him about that, Your Honor. I think that was just a misunderstanding. He stated that he did not know that they needed him to stay in the building to do any other follow-up tests, but I've explained to him that once there is a positive alcohol test, that they require the confirmation test.
All right. Anything else?
Nothing else.
So I set it for May 6, 9 a.m. But at this point, defendant's bond is revoked.
Thank you.
That's in there. Court calls case People versus Justin Robinson.
And is that on behalf of People?
Good afternoon, Your Honor. Assistant Public Defender Carson Bovesa on behalf of Mr. Justin Robinson, who's present to my right. Mr. Robinson, can you state your full name for the record, please?
Justin Robinson.
Thank you. What are we doing?
Today is the date and time set for a PCC. We'd be respectfully requesting to set this for a preliminary exam at this time.
Well, discovery complete.
To my knowledge, yes. We would ask for the earliest date available.
People have their witnesses available to 6.
We'll do our best.
Preliminary examination in person will be set May 6, 2025,
9 a.m. before Judge Perry.
9 a.m. before Judge Perry. I will continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Mountain Rucker.
Kevin Adish on behalf of Mr. Rucker. Assistant Public Defender Kevin Adish now officially. Can you say your name for the record?
No record. All right. So you need to take your hand out of your pocket, please.
You can take your hand out of your pocket.
Are you having problems hearing me at all?
I'm deaf in this ear.
All right, hold on. We'll get you.
They're gonna give you that. Thank you.
See, we're a team.
Yeah.
Together.
That's not a team thing.
You can
That's you being in everybody's business. That's all that is. That doesn't make a team.
You know, whatever the outcome, you can get all credit.
She's just in everybody's stuff. Does that help you, sir?
Yes, sir.
Okay. Your Honor, we're going to be asking for an adjournment. I hadn't been able to get in contact with Mr. Rucker. It is because he isn't able to have a phone based on his bond conditions. I was going to request that he be able to buy a flip phone and use it, one that does not connect to the internet. That way we are able to talk to him about his case.
Oh, I see. People have a position on this.
Does he have no sort of bond condition that says no phone use, or is it no using a device?
That's the internet connection.
So he's able to.
Device.
Okay. Okay. We'll talk about that later.
Where do you get a flip phone? Never mind. My bad.
From somewhere, I don't know.
What?
I can Google it. I'm not sure right now. I have one in my room. No, it's my old one.
You are not old enough to have had a flip.
It's not. It technically it slides. It doesn't flip. It slides.
You are not old enough to have a true flip phone. I'm just telling you right now.
All right. I'll get rid of it.
People stopped using those probably when you were about 2.
That's so funny.
All right.
All right.
I'll turn this to May 15, 2025, 9 a.m. If you arrange for the flip phone or the non-phone, what I'm going to suggest you do is at least take a picture of the packaging and maybe the serial number above it so that there isn't any miscommunication. Get that to the prosecutor.
Definitely.
Okay.
Thank you, Your Honor.
Thank you. Bond continued. Thank you, sir.
Thank you.
He's got it.
I'll take your.
No, it's okay. See,
Great.
Ms. Cannon was all in the business and everything until it came time to, no, you show back up now, she's not all up in. Court calls the case People versus LaDonta Skinner.
And on behalf of People,
Assistant Public Defender Jay Bell on behalf of Mr. Skinner, who opposes.
Good afternoon, Your Honor.
Good afternoon. Thank you.
Your Honor, we're just seeking to set for preliminary examination on this.
Already. Better be bringing the track shoes May 6th. Discovery is complete.
Yes, Your Honor.
People have their witnesses available May 6th.
we'll do our best, Your Honor.
Preliminary examination in person, May 6th, 2025 at
Well, yeah, before you.
12 noon before me. On continue.
Thank you. All right, we'll be in touch, okay? All right.
Court calls case People versus Ira Smith.
Jennifer Douglas for People. Stephanie Cannon on behalf of Mr. Smith, who is not present, Your Honor. I would just ask for a show cause. I'm just asking.
Really?
I'm just asking.
You
Just,
got that from Daddy, didn't you?
he's
That's part of this team thing.
my hero.
Did you ask him when you got that from him how well that works?
How well does it work for you?
What?
Does it work well?
There's no saying if you don't ask, the answer's always no. The answer's always been.
Central warrant will issue for defendant's failure to appear. Bond 10,000, cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Was that a whole team thing too? No, nobody else was like. Court calls the case, People versus Virgil Stafford. Stafford.
Madam Prosecutor. Stephanie Cannon on behalf of Mr. Stafford, who is also not present, Your Honor. However, I did provide this court with confirmation that he is currently hospitalized at Havenwood Hospital. I've given it to Madam Prosecutor as well. We're just simply asking for an adjournment of this matter. And I do believe there is a green sheet that should have been provided.
But you don't know.
I mean, I feel confident in your staff, so I'm gonna go with yes. Good answer.
In my staff?
Good answer. Good answer. I gave it to Ann. I did, I promise. Oh, cool. Yes. Good answer. Good answer. Okay.
She had no idea.
I did. So Your Honor, I'm asking for a 2-week adjournment to give me the opportunity to speak with him to see how we're going to proceed on this case.
May 15th, 2025.
Thank you, Your Honor.
And the bond continues. Thank you. Court does call the case of the People versus Derek Stewart.
And Your Honor, Alexis Pluma appearing on behalf of Mr. Stewart, who is in the vestibule right now. Wait, which Stewart? It's Derek Stewart.
Yelling. Who's that yelling? No, who is yelling? Why were you yelling?
I didn't hear the first name.
Talk about.
And Mr. Stewart, could you state your full name?
Thank you, sir.
Your Honor, our office has received a copy of the competency evaluation in this matter. Have gone over it with Mr. Stewart, and we are not objecting to the findings of that report.
I am objecting. That the defendant at this time is incompetent to stand trial, but with treatment would likely regain competence within a statutory period of time.
Yes.
Any other additional evidence from either side?
No.
I need a 3 months because. Excuse me. Set a review, competency review hearing July 24th, 2025 at 9 a.m. Counsel, you'll prepare the requisite order.
Yes, and Your Honor, if I could briefly address bond.
Yes.
So I, for whatever reason in on-base, I'm not able to find the most recent community corrections bond order. But Mr. Stewart is on some kind of a GPS tether at the moment. I'm not sure if it's just tracking or if it's an exclusion zone. That is both very uncomfortable for him, and because he currently doesn't have housing, it's very difficult for him to make sure that it's charged to get somewhere where he can plug it in. I will note that he has been, at least the last few times that I've represented him, he has appeared on time for court. Nothing, nothing by way of new offenses. He's compliant on bond. He would just ask Your Honor to consider removing that tether.
Any response from people?
Your Honor, I understand it may be uncomfortable, but unfortunately, the nature of these allegations, seem to require it. Mr. Stewart is charged.
I'm disabled. What am I?
Pay attention to the jail.
Y'all will, I'm just in it.
May I continue?
Go ahead.
The nature of these allegations appear to require Mr. Stewart is charged with one count of witnesses bribing, intimidating, and interfering. Essentially, the allegations in this report describe Mr. Stewart. These are physical confrontations in terms of rushing this individual in this area. Now, him no longer living, I think, close by may assist with that, but I don't have any assurance that Mr. Stewart is going to be able to essentially not contact this person. I might feel differently if we were dealing with text messages and emails and phone calls and that sort of thing. These are physical confrontations.
Your Honor, I do believe Mr. Stewart is no longer living at that location. This incident occurred back in 2022. At the time, I believe Mr. Stewart was still at that apartment complex. He had since been evicted and isn't staying there anymore. To my understanding that you are usually in downtown Ann Arbor, or Delano's Center as his mailing address. Okay. But either way, I don't think he plans to or has been going back to that location.
Well, you evicted me, why should I go back?
All right, the original order, as it may help, is, at least as I see it, the original order was back on September 21st of 2023. However, there was a period in time at which for whatever reason, as it was proceeding, it came through, and then I think at some point the defendant bench warranted, and there were some other issues. At later date, I then set aside the bench warrant, reinstated his previous bond conditions, which is why he has the tether on now. Okay. So I'm a bit reluctant. Well, what I'm going to do is this. I'm going to deny your request at this moment. And what you would need to do is file a written motion that I can consider fully as to the release, where he is, and lay all of that out to me. So at this time, the bond motion for bond modification is denied. Thank you.
Okay. Thank you.
Bond will continue.
24th of July.
Huh? Oh, is that what it is? Okay. I don't know what it is. Okay. Court calls the case, People versus Elijah Stewart.
Thank you, Your Honor. Jacob Kennedy on behalf of the people. Cheers.
On behalf of Mr. Stewart, who is appearing to my right. Mr. Stewart, when you are present, please state your name for the record.
Is Elijah Stewart.
Thank you. And Your Honor, we're simply asking for a 2-week adjournment of this matter for
You didn't know?
some additional investigation. No, yes.
Probable cause conference will be adjourned May 15th, 2025, 9 a.m.
And Your Honor, if I may, could you please remind the defendant that there is to be no one having third-party contact with the victim in this case?
Why am I reminding him of that? What do you have?
Kind of my understanding, he has been having some contact with the victim.
Whatsoever.
Stay facing forward.
Your Honor, this is the first I'm hearing about this. I've spoken to my.
I don't even know what it is. So what are the specifics? I mean, because I'm not going to admonish somebody if they're not doing anything.
Thank you.
Oh, you were going to sign on to it like I care. No.
My victim advocates informed me that someone's been coming to the victim's house We don't have any information as to who that person is.
That's attached to him?
It's unclear at this time. We just want to make sure that no contact.
Well, I think he understands his bond conditions, but I don't even see that it's remotely approaching any type of bond violation. I'm not gonna admonish him. I'll
Thank
wait
you.
till you give me something that I can do. Bond will continue. Thank you.
Thank you.
All right, okay. So I don't know. I don't have any information. Court does call the case of the People versus Cynthia Subtle.
APA Rachel McDuffie for the people.
And Assistant Public Subtle statement the record wants to approach. Cynthia Subtle.
All right, what are we doing?
Your Honor, we have we've come to a resolution in this matter, for an advice rights form as well as the sentencing judge waiver. If Ms. McDuffie can offer on the record.
Well, I'm not, okay. I think it's back one step. Miss, my apologies, Miss Soto adjourned.
Go ahead.
Okay, I didn't know if you were waiting for this.
No, I don't know what, go ahead.
Miss Soto adjourned last time so that she can make one last payment to complete her restitution payments to get the misdemeanor offer in this case. Ms. Soto did in fact make that payment, but it was extremely recently, I think within the last hour or so. So I did let Mr. Carriac really know that I was not going to be able to get the plea form filled out before the case was called.
I apologize. I must have misunderstood her, Judge. I thought she said that she would get the plea form filled out before the case is called, after we confirmed that the payment was made. That's my apology. I literally missed the word.
I'm glad that communication is working so well.
It's not.
So if the court was willing to pass that,
No,
if not, we can.
no, I'm not.
Okay.
I'm sorry. I would normally do it, but
Okay.
you can blame that person standing next to you. Wow. 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 The funniest thing is I've never seen I can really move that fast. Anyway.
Okay, so we're obviously.
Why don't I just put it out to the 6 in the morning? Okay. So probable cause conference May 6, 2025.
Okay.
9 a.m.
Okay.
Bond continue.
All right. Thank you so much, Judge. I'm sorry about that. Thank you.
Court calls the case of the People versus Troy Swope.
For those are people.
Assistant Public Defender Chinazi K. I can rule you on behalf of Mr. Troy Swope. Don't he was in here a moment ago? If I can just check for him in the hallway.
Sure.
Swope.
Swope. Oh, she's gonna mess it up. You want me to call for him and then she gets the name wrong? This isn't gonna work. I can really, good job. Not only have you lost a client, you now lost another attorney.
This is for Swope. This is for Settle. I'm sorry, Judge. Settle. Okay. Can we recall the case, Judge? She went to the restroom, she said. I'm here with you.
Well, no, he went to the restroom. That's fine. I just didn't trust, like, you laughed and then Cannon said something. I didn't trust him.
He is here, Judge. Glad to have a green sheet for this. Here, and I'm handing the court a green sheet now. We're asking for an adjournment in this matter. Mr. Swope has been having some medical issues, so he was in and out of the hospital. Well, he was in the hospital. We weren't able to have contact with him. Obviously, he's here. I'll confirm his contact information and see if we can figure out what's going on this case and come to a resolution with the people. We are in communications with them in regards to a resolution, but we have not been extended an offer yet.
Go ahead.
I think that before we get to the adjournment, we should perhaps address bond. There was the violation report sent out indicating that Mr. Swope was released and on April 12th. And that he was supposed to be reporting to community corrections, which he never did. He did not go to the community corrections for intake, let alone the 2 times a week testing that he's supposed to undergo, Your Honor. My understanding is that Mr. Swope did not appear to have money, Your Honor. So it does not appear that there is a legitimate reason for Mr. Swope not showing up. At the very least for intake, he really putting up for to pay for some particular tests. And my understanding is that he'd still be able to test, he just might end up owing some money. So Your Honor, at this time, I believe that Mr. Swope is in violation of his bond conditions and that perhaps it would be appropriate so that he came today. However, we have no idea whether he's been using substances during this time. And how or why he did not even show up for anything.
And Your Honor, I did have a conversation with the people in regards to that. She did ask what the reason for his failure to report was, and everything that she stated is correct. I spoke with Mr. Swope. He stated that he did not have any money and he thought that he was required to present money at community corrections. Now, if there's a change in the rule, I did tell him that we still encourage our clients to go and form community corrections.
To go.
Yeah.
He just hasn't done anything. Sure. Is he working?
No, he's not, Your Honor.
If I were to test you right now, you're gonna test clean? Don't, you're not. I didn't think so. Mr. Allen. Your adjournment. I'll set this probable cause conference for May 6th, 2025, 9 a.m. At this point, defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
Court does call the case, People versus John Terry.
Your Honor, Alexis, am appearing with and on behalf of Mr. Terry, who is approaching. Mr. Terry, could you state your full name?
John Martin Terry.
Oh, I would have taken the other charges. No, I'm kidding.
Your Honor, we are just asking for a brief 2-week adjournment. Mr. Terry is receiving some treatment. He's just going to get some letters from his providers to give to the prosecution as proof.
Oh, is that correct, sir?
Yes, sir.
All right. No objection from the people. How much time did you need? Did you just say you want the 15th?
2 weeks, is that the 6th?
I don't know.
I don't know either.
12 days out. So I don't have the 8th, which
Oh, okay.
So you can have the 6th or the 15th, which is going to work better for you.
15th.
Of course I need that. Probable cause conference, May 15th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you, Your Honor.
Thank you, sir. Let's call the case, People versus Delco Thomas.
Thank you, Your Honor. Constable Basin on behalf of Mr. Delco Thomas, who's present to my right. Can you state your full name for the record, please, Mr. Thomas?
Delco Thomas.
Thank you.
Your Honor, today is the date and time set for PCC. At this time, requesting a brief adjournment. There is some additional discovery my client wants to provide me that I would like to take a look at
with him. Okay, probable cause conference, May 15th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Lewis Varaldi.
Herman on behalf of Mr. Varaldi appearing on Zoom. Mr. Varaldi, can you state your name for the record?
Louis Varaldi.
All right. When,
Your Honor, we have come to a resolution with prosecution, but we are going to be asking, sorry, I confused. That's my bad. We're gonna be asking for an adjournment because we need to continue plea negotiations with prosecution.
got it.
Yeah, that was another thing.
That's because you've been hanging around Cannon. I'm just saying that will happen to you. So we'll do the probable cause conference without objection. I'll adjourn this to May 15th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Continue.
I'll talk to you, Mr. Burrows.
Thank you.
Court does call the case, the people versus Stephen Watson.
Alice, and on behalf of the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Watson, Your Honor.
Mr. Watson, I need you to turn on your camera and unmute. Yeah, well, that's gonna be a problem.
Yes, Your Honor.
Mr. Watson?
Your Honor,
where is he?
He's at the St. Joe's Hospital. He contacted our office, said he was at St. Joe's Hospital with a sick family member. He is endeavoring to get proof to us. I asked if he could appear by Zoom. I gave him the information just in case, but I'm asking now that he be allowed to appear by Zoom for the probable cause conference. Looks like he's standing outside of St. Joe's. Mr. Watson, can you hear and can you state your name?
No audio connection.
There's no audio connection.
Tell you what I'm gonna do. I'll adjourn this 1 week out, May 1st. Given all of the circumstances, May 1st, 2025, 9 a.m.
Thank you, Judge.
At that moment, but your client may need to be prepared to go in, given the results I'm seeing.
Understood.
Court calls the case, people versus Jelani Wright.
Jennifer Douglas for the people.
Assistant Public Defender Davy Lee on behalf of Mr. Wright, who is approaching from my immediate right.
Thank you, sir.
And we're going to be requesting an adjournment today. We have reached a resolution in this matter, however, that requires the upfront payment of $1,000 by Mr. Wright, and he's going to be needing a couple weeks to come up with some money.
Okay, how much time are you gonna need?
2 weeks, Your Honor.
I was asking him. Is 2 weeks gonna work for you?
Yes, that's what I told my lawyer.
Okay, but is that gonna work for you?
Yes.
I don't. Probable cause conference, May 15th, 2025, 9 a.m. Give you a little bit more time than that. Try to make sure it gets done. Okay. Thank you.
Thank you, Your Honor.
Court calls the case, people versus Roman Whitfield.
Jennifer Douglas for the people. And Assistant Public Defender, Your Honor, on behalf of Mr. Rowland. State your name for the record.
Roman Whitfield.
Judge, I do have a green form.
I do not.
I have a green form to submit to the court. I didn't finish.
Really, Gaddy? Yeah, I know he did. He did. I didn't think that was. I didn't think that was you. The old fish tank. There it is. All right. How much time are you gonna need this open?
There's just a little bit of information that the people and I need to flesh out, Judge. It's 2 weeks now. 2 weeks should be fine, Judge.
You want the 6th or the 15th? Jeez,
That's which one?
we've been at this all day. I can just close. Oh, now you're gonna ask him?
The 6th is fine, Judge.
The 6th?
Yes, Your Honor.
Okay. May 6th, 2025, 9 a.m.
Thank you, Your Honor. You too.
Because he told you hi last time. Yeah, he told you. Take care now.
All right, I think, that's it for that block. Oh, rather efficient. Thank you, Mr. Gaddy, for being here and keeping us efficient on this.
It's a skill.
I know. You need to talk to the rest of your folks. Because they were trying to mess it up. Court's gonna stand in recess.